here together with my learned friend, Ms. Punzi Lesokela, for the applicant.
Thank you, Mr. Mechi.
Good morning, Justices. May it please the Court, I appear for the first respondent in this matter, together with my learned friends, Mr. Muela, Ms. Mamuepa, Mr. Mavungu, and Ms. Palma Siwunu. As the Court pleases.
Thank you, Mr. Lefoko.
As it pleases the Court, my lords.
Yes.
Matibeli, together with Advocate de Klerk, and Muke, represent the second and third respondents.
Thank you very much. Let's deal with several preliminary issues. Is there more? Sorry. Forgive me.
Another friend, Ms. Makola, and I appear for the applicant for the admitted as a friend.
Sorry, I couldn't hear that. I'm sorry, Mr. Lawal, I didn't hear that properly. Say it again.
I appear together with my learned friend, Ms. Makola, for the amicus applicant, Black House Collective Foundation, on the instructions of RMT attorneys.
Thank you. Thank you, Mr. Lawal. Let us deal with some preliminary issues before we get to the business of the day. And that deals, first of all, with the amicus application, Mr. Ngulwana. As I have it at the moment, although the applicant and the first respondent have expressed no view, the National Prosecuting Authority has opposed the application.
There appears to be a new development, Justices. Perhaps our learned friend, NPA, may place
Yes. What is the position?
As it pleases the Court, my lord, we are not opposing the application.
What does this notice of opposition I have mean?
That relates to Part B, wherein we have to deal with some unfounded and malicious allegations leveled against the second and third respondent. But for Part A, we are not opposing it.
Well, I take it you've read the affidavits in the amicus application.
That's correct.
So how will that assist us deciding the agenda for today, which is whether or not there should be an interim interdict?
Well, our view is that whatever they're raising will not, assist the court in as far as Part A is concerned.
Not apparent to me that you've actually applied your mind to that issue.
Sorry?
It's not apparent to me that you've actually applied your mind to the question I posed to you. Is the taking for granted that the amicus's contributions are relevant to Part B, what possible assistance can they offer this court, qua amicus, in deciding whether or not there should be an interim interdict?
We submit that, but we leave that to the court, but we submit that no case has been made out in as far as Part A is concerned, because there's nothing that they are going to add.
All right. Well, then I think I understand you. Thank you, Mr. Mandavidi. Back to you, Mr. Ngwana. There's a couple of issues. First of all, it doesn't appear to me on the face of it that the contribution you can make to this debate is relevant to this particular part. What you've set out in your papers will certainly constitute a material contribution to the debate in Part B. But over and above that, you've not sought to join the Minister of Justice, which would be a relevant step to take if you're going to challenge the constitutionality of the present arrangements concerning who is or isn't entitled to bring a private prosecution. So I would invite you to consider whether you need to amplify your papers in that regard. And our prima facie view is that you needn't participate in this particular set of proceedings, but you should persist with joining in Part B after and with the Minister of Justice, and the matter can then be taken forward at that stage. And lastly, while I'm just putting points to you to comment on, reading the thrust of several of your submissions, you might want to reconsider whether you seek to join as an interested party rather than as an amicus. An amicus wouldn't, as your papers indicate, be expected to express partisan views, which you're entitled to. And it may be that the exact status of your joinder needs to be refined.
Thank you. Well, Justice Sullivan, let me start with the issue as far as whether we should be part of Part B and not part of Part A. Perhaps it's an issue that I'd have to address in detail. You will have seen in reading both our heads of argument, perhaps in founding, supporting of the amicus, that we refer even to the papers of the President, that the President considers our submission as being relevant to the determination of the application.
Perhaps I've misstated myself. I'm not addressing the question of whether or not it's appropriate for you to be part of Part B. I'm making that assumption. I'm simply pointing to you at this stage is it's not apparent to us that you have a substantial contribution to make to whether or not there should be an interim interdict.
Well, then perhaps I should then address the court on that very question.
Please.
Very substantial. Your Lordship will have read our heads of argument. We have prepared a note as a court address just to limit the scope of our argument. If we can head that up, it's only 15 pages. It summarizes the case that we make in our heads of argument as well as the founding of the papers.
Yes, I'd rather you skip that for the moment and simply directly address me on the point I've raised. We're sitting in an urgent court without wanting to make it sound disparaging. You have sought to gate crash an urgent application, and that creates a disorderly dimension to the proceedings. Whereas on the face of it, your participation in the main debate will be valuable. Insofar as our limited agenda today is to determine whether or not the applicants made out a case on an urgent interim interdict, it's not apparent that the scholarship which you have marshalled is relevant to address those rather well-established principles.
Justice Sullivan, I submit with respect that it may be useful for the court to at least entertain us for no longer than 20 minutes to address specifically why the amicus is seeking to join as an amicus would be of assistance to this court in Part A and in Part B.
Well, I hope that you can make the bull point in less than 20 minutes as to why you can help us on the interdict. Perhaps we can start with the punchline. Perhaps we can start with the punchline. What is it that you're going to say that Mr. Mpofu is not going to say on the interim interdict?
If I can take you, if you've seen our note, I just want to take you to that point.
Yes, we'll hand up the note, please. Hand up the note.
Points that we made, specifically as part of we summarize
Paragraph 31.
paragraph 31.
Yes.
We say that the first prosecution that we made is that the facts of this case demonstrate that the requirement of the security prosecution may serve as an impediment or unjustified limitation of the Section 34 right of access to court by the prosecutor. The second point is that the National Prosecuting Authority is very conduct itself without fear, favor, or prejudice. Third is the slap suit defense, which they have now been developed on the federal side, that they no longer pursue punitive cost order is the legal representative. So that argument would be slightly tailored. And the fourth point relates to the equality provision. He said all these issues are canvassed in great detail in our legislation.
They are indeed, and they're all relevant to Part B. I will, in due course, be very interested in hearing you argue all of these in the second leg of this case. But today, the only agenda in this urgent court is whether or not the applicant has made out a case for an interim interdict. And if what you have just pointed out to me, with which I was already familiar, is the thrust of what you want to advance, I appreciate the scholarship that's gone into what you put together. But I do not see how that will contribute, other than to lengthening the hearing in dealing with whether or not there's an interim interdict.
Justice Sullivan, may I, before sitting down, just direct you to paragraph 104 to 105. It's a case line 010-44.
In whose papers are these?
These are the President's papers. It's a reply affidavit. In which
Give me the page number again, please.
It's a page.
it's, well, I've got case line reference.
Yes, case line. That's fine.
010-44 at paragraphs 104 to 105. It's the point we advance at paragraph 25 of the note we just handed up, where the President,
That doesn't seem to be the correct page. Paragraph 104, you said.
paragraphs 104 to 105, they cited a judgment.
Just give me the
That's
page
page-
number again.
that's 54.
010.
010-44 at paragraphs 104.
Oh, that's in the replying affidavit,
Yes.
not the first set of papers.
Where the President says, and of course this is a trite issue, the President says his interdict application must be determined with reference to the grounds of review. He says this court must have a peek into the grounds of review. And so one of the considerations by this court in order to determine whether or not to grant an interim interdict is prospects of success in the review. And so our argument in all 4 points that we make is that the prospect of success in Part B are poor. And so that is why the amicus should be heard in Part A on the President's own argument, because this court has to consider the prospects of success in Part B. Other than that, there's nothing more we can add.
Thank you.
Thank you, Justice.
Is there any comment that any other counsel want to make on this issue?
I need to clarify the instruction that my friend conveyed, that the President does not assist in a punitive court order in relation to both the litigant, the first respondent, and the attorneys. Will be asking only for a party-in-party cost against the first respondent.
Mr. Kofo, anything you want to add?
Yes, Justices, yes. Now, the remarks by Mr. Manager to deal with my concern. I would have raised the issue of the punitive cost order being raised in Part A itself as one of the issues raised by the amicus. But once the concession is made that
Yes.
those costs are
Do you want to add anything, Mr. Matabedi?
Nothing.
Mr.
I'm
Guam?
sorry, Justice
Rich,
Sullivan. We are
certainly.
not making any concession that the punitive cost order issue is not relevant in relation to Part A.
Yes.
My friend Mr. Bob says he likes my concession, not his.
Yes. No, I've got the point. Okay. Let's just talk about this. we've taken a view that we should not hear the Blockhouse Collective Foundation as an intervening party in Part A. That statement does not in any way detract from any entitlement that that particular party has to participate in Part B. And I invite Mr. Ugwana's attorney to approach me with a view to arranging a consent order to admit that party as an intervening party in Part B once the appropriate arrangements have been made, either provisionally or finally, to join the Minister of Justice, so that the articulation of the debate, which is fundamental to the intervening party's interest in the matter, can be properly dealt with. Thank you, Mr. Ugwana.
I'm sorry, Justice Sutherland. The point I forgot to make is in relation to the joint alpha minister. You will have noted, both in the founders affidavit and in our heads of argument, that we make it absolutely clear that we are not launching a constitutional attack. We are simply saying the court should consider those submissions that we make, not with a view to determining whether or not there is constitutional invalidity, specifically in relation to Section 7. So
Very well.
It would not be necessary for us to join the Minister of Justice.
If you limit your contention to that, then it's correct. You won't need the Minister. But obviously, that's one less arrow in your quiver. So that's a choice you make. Thank you. So, Mr. Mpofu.
Well, before we celebrate that withdrawal, I will take those remarks as applying to me, because we do intend to raise that issue in Part B.
Yes.
Escort.
Yes, indeed. Well, it seems that your pragmatism has been overtaken by Mr. Mpofu's zeal.
Well, we took the view that the amicus will not have the way forward.
No, I take that point. Can I make this preliminary observation? I've said it twice already, so let me emphasize it now. There's a great deal to be dealt with in this controversy. We are not going to trespass on the relief in Part B. That involves many very delicate issues which require to be dealt with unhurriedly and with reflection. The agenda for today is to determine whether or not there should be an interim interdict pending a date to be arranged for that hearing. After these proceedings, I will invite the parties to see me about the earliest possible date for that hearing to take place. And the extent to which we need to hear argument today is limited to the issues which are relevant to the interim interdict. As I have them, other than some frills which I shall deal with presently, the jurisdiction of this court to even consider this relief is point 1. Point 2 is whether it's urgent. And the other 4 issues relate to the traditional elements of an interim interdict. That is what we need to hear argument on. We will give a judgment and order on that, and with such expedition as is prudent, get to round 2 in this matter in due course. To that end, although there was a very generous indication by one of the council about how many days this matter was going to take, we are of the view that the issues are of such a nature that we can do justice to this matter if we give to the applicant 60 minutes to present its case, to the first respondent 90 minutes, to the MPA an opportunity to say hello, and to the applicant 20 minutes for a reply if one is needed. So that will be the agenda for the day.
Well, yes, well, it was 5 of the council, not 1. But with that as it may, I just wanted to, from that summary, my lord, I gather implicitly, without saying it, that your lordships are not inclined to hear the preliminary points regarding whether this court, as you correctly put it, should even be sitting here, or whether the matter is urgent up front. Am I correct in that?
I do want to hear you on both those points, and obviously what you have to say about the interim interdict itself. So that seems to me to cover what needs to be dealt with today. So I appreciate the jurisdictional point is a leading point you want to make, and I do want to hear you on that.
I'm sorry, maybe I didn't ask.
You mean as a preliminary approach?
Yes, yes. I'm asking whether the real question I'm asking is whether we're going to have a 1 stage or 2 stages.
So we'll have 1 stage.
Yes. Okay. Now, if we're going to have 1 stage, my lord, then which I always support, subject to, of course, my right of reply on the preliminary points, which that's the one.
Yes. Yes.
Thank you. In other words, on the points in the minute.
Yes.
Thank you.
Right. Let me deal with some points which are unworthy of consideration, which have been raised on the papers. I deal with them in no particular order. There's a complaint raised about the clumsy commissioning of the founding affidavit. It was clumsy. It is, in a sense, inexcusable, but it's the practice of this court not to take that kind of complaint seriously. And the fact that the affidavit has now been repaired by the Commissioner giving the relevant information is sufficient for us to overlook that point. The same thing goes for the omission of a case number. We take a similar view about the point raised about whether or not the security which the first respondent, was supposed to pay before the summons was issued was actually paid afterwards. We are not interested in that point either. To the extent that condonation is required, it will be granted in due course. There is also another point about whether the National Director of Prosecutions should have nominally been joined rather than the National Prosecuting Authority as a whole. We are not interested in that point either. And that really disposes of all the precious points. That leaves us to get to grips with what the case is really about. So, at 10:28, Mr. Monechi, your 60 minutes begins.
My Lord, with the court's guidance, I shall deal first with the question of jurisdiction, and then address the question of agency and the requirements for interim. Just by way of a background, the Eclipse issue really is whether the private prosecution may be interdicted pending Part B, where in Part B the validity of the summons, in other words, the root of the prosecution itself is challenged, and we submit that on established authority, the High Court has power to grant relief which would prevent a private prosecution from being proceeded, either as final relief in the form of an interdict or by way of a referee. And in those circumstances, the court has inherent jurisdiction to grant interim relief to prevent injustice from happening. That in broad outline is our submission. And there is ample authority in our courts that indeed can be, it's a power that the High Court can confer. I'll take my words to the cases dealing with jurisdiction, which we addressed in our heads of argument from page 11-38. And may I say, as we say in our heads of argument, what animates the application is really the rule of law. That the ability to prosecute privately is a privilege granted on specific conditions, is not a power that is granted to private parties originally under the Constitution. Under the Constitution, the National Prosecuting Authority is the civil prosecuting authority. And the only time that a private party privately prosecute is if the NPA has considered the complaint, the particular complaint against a particular suspect, and has declined to prosecute. It's only in those circumstances. And all the other requirements for the private prosecution are met, then a private prosecution is lawful. But absent compliance with those conditions, the rule of law puts its face against a private prosecution. And courts are entitled to prevent and to vindicate the rule of law, both in the interim and in the final interdict. And I refer to cases starting from cases prior to our Constitution. Indeed, the first case we refer to, my lords, is a judgment of the Transvaal Provincial Division in Solomon. And prior to that, we made the submission, and I emphasize it, that jurisdiction is determined on the pleaded case. It's not determined on how one party understands the case of the other. It is what is the case that we're bringing to court. And we brought to court the case that the private prosecution fails to comply with the jurisdictional requirements of sections 7 and 9 of the CPA. Now bear in mind what the court has said about section 9. Can I just say now, whereas the court has indicated that failure to comply with the security requirement is a matter that may be condoned. What we have before you, my lords, is confirmation by the applicant in the latest affidavit that in fact security hasn't been paid. What was presented as an annexure to the summons reflecting proof of security is not in fact proof of security. What you are told is money has been set aside with the state with the attorneys. It is reflected in the books of the attorneys. Now, you're not taken into confidence by the attorney or the applicant.
No, I appreciate that.
Yes, but I'm just prefacing
obviously, if they don't fix it, by the time we get to part B, that's a problem. But it's eminently fixable, and I don't really want to spend any time on it.
Quite correct. All I'm saying is an additional point of clear, admitted non-compliance that should weigh with the court in determining Part A, because it may or may not be fixed. But we'll cross the bridge when we get to Part B. Coming back to the question of jurisdiction, so we quoted a paragraph 112 from the case.
But sorry, Mr. Manager, if you're saying that in relation to Part A, it needs to be taken into account, but I thought the order that was made, or the pronouncement which was made by my brother, was that it's something that can be fixed, and it's a technical point that the court is not going to allow.
I'll come back to it when I deal with the question of compliance, because we would submit it's not as straightforward as that from the case law that we've seen. And the court might need to reflect on it. It may still reach the same conclusion, but at least hear us out on that point. Now, the case of Solomon versus Magistrate Victoria, we submit confirms that a private prosecutor stands on a different footing from a public prosecutor, because the ability to prosecute, the right to prosecute in the case of a private prosecutor, arises from compliance with the statutory requirements of the Section 7 and 9 of the CPA. And absent compliance, the private prosecution is irregular and can be interdicted. And if I can take to the paragraph that we quoted from, the actual judgment, which I have, and perhaps I should, so that the court can follow me, read from the judgment in Solomon.
You loaded it to case lines in English.
We loaded it to case lines. So Solomon is at page 014-279. And there are two important remarks to make before dealing with that judgment, is that it concerns a prosecution issued in the magistrate's court, so it's of an inferior court. But what the court clarifies there is that there's a power to interdict an irregular private prosecution, and that it would really make no sense to suggest that the court, even if the this was a prosecution in the High Court, the High Court would not be able to interdict conduct by its own officials like the registrar issuing a summons which is unlawful, without, in other words, not being able to provide a remedy for that. And in the discussion, which you will see at page 014-280, and I point out that this is a judgment of the TPD, formerly 1950, of Robert J. And
Mr. Maneti, you say
014-280.
280.
Yes.
Thank you, sir.
What you will see at the foot of the page, the paragraph saying, I can find in the sections relied upon no evidence. And the point there was to deal with the provisions of the Criminal Procedure Act as introduced in 1917, which allows for a private prosecutor to take steps. And the argument was some of these provisions, including the provisions in the Criminal Procedure Act, exhaust the powers of the court to intervene and grant interim relief where private prosecution is complained to be unlawful. And what the court says at the foot of that page is, I can find in the sections relied upon no evidence that the provisions relating to the cost of unfounded and vexatious prosecutions or the title of the prosecutor to bring the proceedings were intended by the legislature to be exhaustive and to exclude any right to invoke the assistance of the Supreme Court, as the applicant now does. You recall that they argue that because you can raise the title of the prosecutor in the actual criminal proceedings, and you can get costs if those proceedings are unsuccessful, that means you must go there and raise your complaint there. You are in a wrong court. And the court says that doesn't exhaustively exclude the jurisdiction of the court. And it says, Mr. Retief maintained, I think in support of this contention, that the provisions referred to were exhaustive, that under sections 17 and 18 of the Act, the private party who had obtained the Attorney General's certificate was given an absolute right to prosecute, of which he could not be deprived by the court. No doubt the sections referred to do bestow a right to prosecute, subject to the necessary conditions, but I cannot take the view that that fact excludes the jurisdiction of the court to interfere on proper course. If Mr. Retief's contention were correct, this court would have no power to intervene, even though it were shown in the clearest possible manner that the party who had instituted the private prosecution had no interest whatever in the outcome of the trial and had embarked upon it for some ulterior motive, such for example as to prevent a business competitor from leaving the country on his lawful business or to delay him in so doing, so clearly for an ulterior purpose. In such a case, if the prosecution were launched in the Superior Court, I do not consider that it could be held that the remedies provided in the sections of the Act to which Mr. Retief referred were exhausted. The taking out of the summons would clearly be an abuse of the process of the court, in that it had been undertaken not with the object of having justice done to a wrongdoer, but in order to enable the prosecutor to harass the accused of fraudulently to defeat his rights. The process of the court provided for a particular purpose would be used not for that purpose, but for the achievement of a totally different object, namely for the oppression of an adversary. The court has an inherent power to prevent abuse of its process by frivolous or vexatious proceedings. And though this power is usually asserted in connection with civil proceedings, it exists in my view equally where the process of abuse is that provided for in the conduct of a private prosecution. In such a case as I postulated, therefore this court would, in my mind, by virtue of its inherent powers, to set aside a criminal summons issued by its own officials or to interdict further proceedings upon it. It is also by virtue of its inherent power that the court interferes to restrain illegalities in inferior courts, either by way of interdict or mandamus or by declaratory order. And you'll see in the paragraph just below the quotation, it says, refers to Mr. Retief referred to Rex vs. Deer, said that the right and duty of prosecution was absolutely under the control and management of the Attorney General. That was the submission. And so long as he complied with the provisions of the law with reference to prosecutions and trials, the court was not entitled to interfere. He argued that similarly, the private prosecution was absolutely under the control and management of the private prosecutor, and that the court could not intervene. The case, my Lord, and we emphasize this point, my Lord, the case of the private prosecutor is, however, different from that of the Attorney General, in that the title of the former, either the private prosecutor, to prosecute, is conditional upon his possession of such an interest as is described in the Act, and the court is therefore entitled to inquire into the question whether he has such an interest or not. So the civil court can provide remedy, can inquire into the issue whether this is a prosecution properly authorized under the CPA Section 7 and Section 9. The next case I refer the court to is the Van Diefente judgment. That is 1996, and the court will find that at 014-285. And that is a judgment of the Cape Provincial Division and also concerns a private prosecution of a judge on the basis that the private prosecutor perceived that the way in which the judge dealt with the matter disclosed an offense.
Does that case offer any further principle, or simply another example of the same proposition?
Yes. What it does is it does go to the deposit and says at least 1,000 rand was paid in that case as a deposit. But I take the court's comments on this one. And the third case, my lord, we offer is the Netco Bank Limited, and another was Kibi Chana, is a judgment of the Eastern Cape Division, judgment of Erasmus J, 2003, also dealing with a challenge to a private prosecution that was not inconsistent with the CPA.
Just give the full reference while you're on it.
The full reference, so the case line reference is 414-176, but the full reference is Netco Bank Limited and another. This is Kilichana, is GCILITSHANA and others, 2004, Volume 1, SA 232. And that note also deals with the question of powers of the High Court, and it says a paragraph 27 of the judgment, which is at page 014-180. Ordinarily, this is dealing with the question of motive and whether it can feature in determining at an interdict stage whether a prosecution should be permitted or not, private prosecution is lawful or not. It says between paragraph 27 and 114-180. Ordinarily, the reasons and motives of a party for institutional legal proceedings are irrelevant. However, when the court finds an attempt made to use for ulterior purposes machinery devised for the better administration of justice, it is the duty of the court to prevent such abuse. But it is a power which has to be exercised with great caution and only in a clear case. The learned judge made the comment in the context of misuse of a rule of the court by one of the litigants. And refers to Zuma. The court held that it has the power to interdict a private prosecution which is irregular, vexatious, or an abuse of the process of the court. The power derives from the inherent jurisdiction of our superior court to prevent abuse of their process. Although such power will be exercised with caution and only in a clear case, the courts will not hesitate to act where necessary, lest the administration of justice attract discretion. The power shall be exercised in the light of all the relevant facts and circumstances, and with due regard to the intention of the legislature as reflected in the statutory provisions, if any, pertaining to the particular proceedings.
All right, I think we have the point, Mr. Nichi. I don't think you need to read all the case law, otherwise you will gobble up all of your 60 minutes quoting.
As the court pleases. And so what those judgments establish, and one of which is a judgment of this, from this division, is that, well, we've referred to Nunandal as well, which is to the same effect.
Yes.
You'll recall in Nunandal, the court even said that a challenge to the validity of a summons or a certificate not prosecute should be brought under Rule 53. And party applies the certificate, paragraph 8 of the judgment, and the summons in that case, in that case, the summons were set aside in relation to security. Interestingly, because they, better than here, they had been in fact an arrangement, an agreement between the parties, between the attorneys, that security shall be, that an amount shall be retained by one of the attorneys to protect the accused in the prosecution. But
But in any event, Nonadal deals with the challenge to the summons on the face of it,
Yes.
not the nolli prosecuting.
It dealt with both. It found that there was no ground for challenging the certificate, nolli prosecuting, but found that there was a basis for the summons, and set aside the summons and left the certificate. But the point I'm making is that the whole private prosecution in that case was invalidated on account of the fact that there are two grounds, the procedural grounds, and the court will find the discussion of that in paragraph page 1014-199 and paragraph 41 to 45. The first was, there was no evidence presented that when the registrar, the clerk, issued the summons, the certificate was presented to the clerk. So it was a procedural matter. The second was, the security was not deposited prior to the summons being issued. And in the language of the statute, the court doesn't have the power to condone, and that is a defect, which can easily be rectified. But the court doesn't have to assist a prosecutor who comes to court firstly, says, there are summons, there's an annexure proving security. When he's challenged on it, he gives stories, and only at the very last minute files an affidavit in which he says, I haven't paid it. It is in the books of the attorney, and anyway, you have powers generally to waive just because there's substantial compliance. How can a failure to comply at all be substantial compliance?
Mr. Manager, as I understand, the point you're putting forward is that as a matter of principle, the court has got jurisdiction.
Yes.
The matters that you are addressing now probably matters that should arise in the discussion on agency.
Quite. But the only reason I was mentioning that is that Nunandal is also authority for the proposition that these challenges can be brought in the civil court, because that was a review by the full bench, or full court. I think they will try to clarify the nomenclature, but that's the point. So that's, if we establish that in terms of its inherent powers, it can intervene by way of review, setting aside, or by way of granting a final stopping the private prosecution in its tracks. And the only question I need to address is, well, if that is the case, is there power to grant interim relief pending either the review or a final interdict? And the job for me there with respect is a lighter one, because once the court has the power to hear a review, the Part B review, it has inherent power to grant pending relief, pending the outcome of that, to preserve, in the interest of justice, for the proper administration of justice, in the control of its own process, but also to prevent any injustice from occurring. Because the injustice we complain about here is being hauled before a criminal court when the proceedings are at root are invalid. So they don't get out of the law, as we say in the papers. It's a different matter with public prosecutions, which are presumptively they are lawful because there are no prior conditions. Once the prosecutor has applied his mind and believes that there's a prima facie case, prospects of success, they institute the proceedings, you must go and plead there. But none consent. I hope that expresses the right expression.
Well, we've got your point. You say that on the strength of the authorities you cite, there's a clear basis for the court to be approached for this form of relief.
Yes.
And they don't have to wait until they appear in order to plea, in order to raise it.
We don't have to.
So that's the point.
At page 011-43, we refer back to the well-established authorities on the court's inherent powers to grant independent. And we refer to the AO Express judgment, which is a well-known judgment regarding licensing, and the court will be familiar with that. But it's clearly there is. And then there are subsequent cases we refer to involving the current president and involving the former President Zuma, in which state proceedings were obtained pending review proceedings, and the interests of justice were applied as the yardstick to determine whether interim relief should be granted. So the final proposition we make, my lords, is that there is established authority. We haven't seen authority to the contrary, other than authorities raised to the context of public prosecutions. And in the context of private prosecutions, there is authority, there is a power, and if there's a power to grant final relief, there's a power to grant interim relief.
Very well.
Then the next point I need to address my notes on is the question of agency. And in addressing it, well, we've addressed it in our heads that
Well, perhaps you can start by simply formulating,
the point.
as of today, what is the fact that demonstrates the urgency you rely on?
Yes, there are 2 points. The primary point is that the criminal proceedings will sit on the 19th of January next year. And the private prosecutor has indicated no intention whatsoever of postponing or removing from the role, because that is competent. In Van Deventer, you will see there was agreement and the private prosecution was removed from the role and the matter ultimately served before court in the ordinary course. But it was not in the ordinary course urgently because there were some changes about keeping to the agreement. But the point of it is the private prosecutor will not budge. He will not remove the matter from the role on the 19th of January. He wants the president to appear in that court as an accused and plead. He says, go there and raise all of his complaints. That pregnant in that statement is accept the breach of your constitutional rights, of your rights for protection in terms of the rule of law, that you're not in, no one is entitled to hold you before a criminal proceeding, private criminal proceeding, when the provisions of section 7 and 9 have not been complied with. Now, my client has no other remedy to avoid that. It will happen on the 19th, and that breach of his rights, by being hauled before that court, remaining in attendance, cannot be reversed. So it's not a case where he can wait till next week and get a remedy or some other time and get a remedy that will substantially assuage his the breach of his rights. That's done. And you'll see in Van Deventer, and we go to now.
But they're saying that you have right to go before that court and plead to that, and that seems to me an alternative.
Yes. My lords, so the court has said that the substantial remedy that you're talking about is a remedy one can obtain in law. Right? So the law provides you protection. Now when he says, go to that court and plead, you have a right. Of course we have a right to go to that court. But we also have a right to assert our constitutional rights and say we cannot be hauled before an unlawful private criminal proceedings. We have those rights. And my client has decided to assert the right that this is entitled to approach this court to protect him from having his rights trampled upon by a private prosecutor who prima facie, and that's the case we have today, prima facie is conducting an unlawful private prosecution. It's not only unlawful, for the submissions we're going to make on the non-compliance, which I'll do in a minute, the non-compliance has significance for the constitutional scheme as well. Because if we can persuade my lords that the non-prosecution certificate that he relies on his own facts, and on the chronology that he gives, cannot relate to a crime committed by the president after the 21st of August 2021.
Well, you're on to arguing what the prima facie right is composed of.
Yes, so the prima facie right, I'm digressing quite right. The prima facie right is to be protected against a private prosecution that breaches the rule of law, breaches his constitutional rights. He's got a constitutional guarantee under the Constitution that his freedom of movement, his liberty and all of those rights cannot be infringed by a private prosecutor acting illegally as this private prosecutors do. That's the first.
Let's just focus in on the critical bit. One can say it in many ways, but fundamentally what you're saying is the personal freedom of the applicant is being jeopardized by a prosecution, by a prosecutor that has no title to do so. So that's the right. Why is that an appropriate formulation of the right you lie on? One of the contentions advanced by the first respondent is that every inhabitant of the country, if charged with a crime, has an obligation to submit to that and come to court and say whatever they want. So when you say, I have a right not to be brought to court at all, where exactly do you seat that right? In the Constitution, in the common law? Where do we find it?
Perhaps I should add submit to the proposition I made. So he's got the right to be hauled before court in a private prosecution not authorized by Section 7 and Section 9 of the CK. Because that is the only source of the power that the prosecutor can exercise. That's the only power the prosecutor can exercise. It must meet those conditions. So it's not just a general right that every individual enjoys in respect of public prosecutions. And that's why even the cases I referred my words to make a clear distinction each time that the position of a private prosecutor is different from the position of a public prosecutor. So one can make the point that if the right authority, the NPA, has issued a summons to you to appear criminally in the court, all the conditions are met, and whatever defenses you raise. But in a private prosecution, the position is different, because you don't get out of the stepping block as a private party to get into court. I'm trying to think of an analogy that can come up even in a public prosecution. Assuming that the Constitution tells us the civil prosecuting authority is the NPA, that you were judged by the NIA and told to report or by the NPA, or any other authority outside of the NPA, and it was so obvious that this is not a constitutional prosecution, it's not a lawful, legal, nothing, there is no legal foundation to it. We would submit, although we are not there even, we are less than that position, that even in that case, it would be hard not to foresee a situation where the civil courts can be approached to prevent a clear breach of our Constitution, the constitutional scheme.
So your point is this: if I am, in terms of the Constitution, vested with rights of freedom, should the state prosecute me, that's an intrusion on my rights of freedom, but it's lawful because it's authorized.
Yes.
And if a private prosecutor wants to intrude on my freedom, it can only do so within the four corners of a nolli prosecution. So if you had a proper case to challenge the validity of the nolli prosecution, then that authorization of the private prosecutor would evaporate.
Yes. Both so it might be a defect that affects the summons because there is something wrong with the nolli, but it might be a defect in the summons itself, either in the manner in which it was obtained or the conditions attended to its obtaining is not consistent with the CPA, Section 9 of the So,
well, what plausible contentions exist on your argument to doubt that this nolli prosecuii doesn't vest the first respondent with authority to bring the applicant before a criminal court?
Just before that, I don't want to forget that I was going to put a second element to my agency.
I beg your pardon.
Yes. So the first respondent says, well, your agency was in relation to the ANC conference, and that is come and gone. But what he doesn't acknowledge, which we have referred to in our heads and in reply, is that the step-aside rule, in fact, continues to apply. So if he is hauled before the criminal court, those of his detractors in the organization, including for present purposes, in this context, the first respondent will say, well, now you are criminally before a court. Now you must step aside. But you step aside not only from your ANC position, you step aside from the national position as president. So the impact is not just on the immediate interests of the president, but it transcends into the interests of the public.
Yes.
So that's the agency point. And I know it's not a basis for agency also, but our learned friends and his team and his clients say this is a very important issue. This court cannot leave us with no answer whether we can come for assistance and whether we can come for assistance agent. I accept that in that course the court will then decide whether it's agent or not. But everybody has put in their papers, here we are in the matter. There is no utility to justice, the administration of justice, or to the public interest to simply say we're not deciding the matter because it's not agent. This is the kind of case we submit in the public interest and on the basis that everything is before this court, that the court must make a determination on whether this court is empowered to assist litigants in these kinds of positions. And especially when they...
Well, it seems to me, but isn't that a proposition that goes to harm? You say, I'm harmed because my personal freedom is being intruded upon. And secondly, I hold a public office which is immediately threatened once I submit to a prosecution. That's the harm aspect.
Yes, I accept that. But as we referred to the judgment in Midwest, that the utility of an interdict, of an interim interdict, and the questions of agency are
intertwined.
And so that is when even the considerations and the requirements for interim interdict are relevant to determining agency, because if we make out a case that cries out for an interim interdict, and the court simply says, we would have helped you for 100 reasons, but sorry, he's not agent, then we submit that's not a proper exercise of that discretion to determine matters on an agent basis. So, my Lord, we submit, and we've dealt with this question of agency in greater detail, and I just wanted to refer the court to the Fender judgment, which, just to the point we just debated, my Lord, that in that court, the fact of the pending criminal prosecution, which was not going to be removed from the hall, was held by the court to manifestly show that the matter is agent. Because what could the accused do? No, nothing. He had to, in a sense, submit himself to the breach of his rights as a
What is the case line reference, Mr.
The case I refer to is Van Deventer. This is Reichenberg, is R-E-I-C-H-E-N-B-E-R and another.
And on case line?
It's 014-285. And I'm asking for my here. You'll find the passage at 014-287. And it's the third paragraph from the foot of the page where the court deals with agency. Just reading from the paragraph just above that, the judge says, and this is Justice Lichtenberg JP, he says, in his answering affidavit, the first respondent disputes that the matter is agent. However, on 13 November 1995, the first respondent agreed to an order in terms whereof the matter was postponed for hearing on 4 December 1995. But he persisted in his argument that the matter is devoid of any agency. So the hearing date was coming up, 4 December. I'm satisfied that this application is indeed manifestly one of agency. That is, that it has properly been brought as such, and that the court is, in terms of Rule 612, entitled to dispense with the prescribed time periods. The applicant is called upon to appear in the criminal court on 21 December 1995. If this application had been brought in the ordinary course, it would not have been heard before then, and in all likelihood, it would only have been heard in the course of the second term of 1996 at the earliest. It is quite clear that the applicant would therefore not be able to obtain redress at an ordinary course.
Right, just pause for a moment, Ms. Minechi. Our technology is interfering with us again. Is this an electricity problem? Well, apparently the recording device has malfunctioned. But let's carry on in any event.
Yes. So I was just reading that point about, I don't know if the court wants me to repeat the
No,
passage.
don't do that. We've got that.
You get the point. Yes. So that's the judgment. So we submit that that is a salutary approach to what he is for. And I think to the question, the second point about criticism on agency, of course, is that he should have come on the 16th or on the holiday, because he was concerned about election. Of course, the point is, as you say, the risk continues that the step aside is there. And secondly, he genuinely asked the first respondent to withdraw the summons, explain what the problems were with the first summons of the 15th of December. There was a conditional offer to withdraw and reissue in order to cure the defects that we identified. And when the applicant said, no, withdraw unconditionally because there are incurable defects, then the first respondent issued a second summons on the 21st of December, and it was clear now that the applicant has to come to court, and the applicant came to court. 6 days during the festive season, my friend complained to me about disturbing his holiday. We know what happens during the festive season. It's not easy to marshal legal representatives to put together an exit application, but the best was done and sufficient time was granted, and in the event the court granted directives which allowed for further time for these interviews. Now, going to the requirement, to the question about the anomaly.
Sorry, Mr. Manesha, the withdrawal of the issuing of the second summons, doesn't that tantamount to a withdrawal of the first? And therefore rectifying the defect that you were complaining about?
Well, if that was what the first respondent said, maybe I would accept that. But the first respondent doesn't say that. It says you must cumulatively do them together.
Yes, he does say it's a supplementary thing.
Yes.
Well, once again, as my brother says, if you issue a summons in identical terms, amplified, there might well be a proper case for an implicit withdrawal of the first, just to make things tidy. But that seems to be a quibble that doesn't deserve our attention.
I'm not bothered about that point. It's in the papers that they came on. I'm going to this substantive component.
Yes.
In one. And that is what we address in our heads at page 011-8. We address the compliance issue at different places, and I'm going to give the court both references in the heads. So the first reference in the heads you will find in the law at page 011-8, starting from paragraph 14, and that carries on to page 011-12. And then we return to that point again. I'm just trying to get my page numbers. Later after dealing with agency, we come back to the language of the section at page 011-21. And that carries on to places. Carries on to page 011-31. So succinctly, my lords, so the way we understand, and we might have misunderstood the case and they can correct us, is that we say they rely on both the non-prosecute certificate of the 6th of June and the non-prosecute certificate of the 21st of November 2022. And my lords will find those certificates in the papers. 21 November is at 001-166.
Dash one? Dash
166. And of that's November. 6 June is yes. So what I need to history of the court is that the certificates do not relate to an offense against the president, but to different persons and to different offenses. And at page, perhaps it might be useful to go to the certificates to see the language employed. So if the court is at the 6 June certificate, it's a different place. There's another one at 001-113. You'll see if the court is at that certificate, I just want to go. You'll see the certificate in terms of section 7.2 of the Act. I, Zungu Julia, appointed Director, Public Prosecutions, KwaZulu-Natal, hereby certify that I've seen all the statements and affidavits on which the charge particularized below is based, and that I decline to prosecute at the instance of the state. So if the charge particularized below, and you will see how the charge is particularized. First is the suspect, William John Downer, Downer SC, and then the complainant is Mr. Zuma. And the alleged crime is a contravention of section 416, 417 of the National Prosecuting Authority Act, 82 of 1996. And then there's the date of the alleged crime, which is 9 August 2021. And then you have a police reference number, which is the Peter Maris reference number on the date. So it is about a specific suspect, about a complaint, alleged crime committed on 9 August 2021, and the crime is particularized. And that is an unauthorized disclosure of confidential information. The president, the allegations against the president, the offense in the summons is not one that the president disclosed confidential information. Is that he is an accessory after the fact and or the justice in respect of this primary offense. So that's the first certificate. The second certificate you will find at 001-166, that's the pre-one. And you will see from the papers, and now the recent affidavit filed overnight gives you the chronology in the Marisburg case in relation to Ms. Moore. And you will see that what they say is, when they initially issued summons against Ms. Moore, they relied on the June certificate. Ms. Moore said, but that only relates to Mr. Downer and not to me. Then they wrote back to the National Prosecuting Authority and said, issue another certificate or whatever, amend or do whatever you can to cover everyone who reached 416 and 417. Even accessories after the fact, we ask you to do that.
But just make me understand, I mean, for my sanity. How does this, for the purposes of agency, affect a crime that would have been committed on the 21st of August? I mean, I don't understand. Because if I look at the certificate, the date of the crime is the 9th of August. Does that relate to the applicant?
Yes, it does. So when they say that...
Yes, I just wanted to understand.
So they say this certificate relates to the applicant. So they used this certificate to issue summons in December 2022 against the applicant. And the reason they do that is they say, well, this second certificate, forget the context that it was requested to deal with their problems facing Ms. Moon's prosecution. They say, well, because the certificate says prosecute any person in connection with this matter, that means even though on the president only comes in because on the 21st of August 2020.
25th.
21st, yeah.
2021. I just wanted to show them. They wrote to him and said, Mr. Downer and the prosecuting team chose not to accept medical reports coming from the military hospital. And
Mr. Manager, do you understand why I was asking? I don't understand.
Yes.
Just help me understand.
yes, can I try that?
Yes.
So our primary submission is that none of these two certificates relate to the president. They relate, firstly, this relates to Mr. Downer, the June certificate, and the correction or the expansion of the certificate in November 2022 also relates to people who committed a crime on the 9th of August 2021, because that's what the certificate says. So it says you must refuse to, so let me just read. I, Elaine Zungu, duly appointed Director of Public Prosecutions, KwaZulu-Natal, hereby certify that I have seen all the statements and affidavits on which the charge particularized below is based, and that I decline to prosecute any person in connection with this matter at the instance of the state. You're still on the charge particularized below. We have charge particularized below is where the complainant is Mr. Zuma. What you don't have anymore is a suspect. They've removed the suspect because they want to catch everyone. But that's not good enough to catch the president, because they still tell you that the alleged crime, the particular charge relates to the contravention of 41(7). That is the disclosure. And the president is not accused of disclosure. They go further and they tell you the date of the alleged crime is the 9th of August 2021. It's not a date later than the 9th of August 2021.
But Mr. Manager, in as far as the applicant is concerned, my understanding is that the complaint is based on accessory after the fact.
Yes.
So just help me also understand, because they're saying you failed to deal with the offenses committed under Section 4 by the two other accused.
Yes. So the question, the rhetorical question we ask is, where in this certificate do you get the impression that the DPP was considering the president's failure to investigate this contravention, and it is that failure that makes it an accessory after the fact?
But isn't it, they would then argue that in reading the formulation in the certificate itself, any other person?
Well, but you can't, as the courts have said numerous times, starting 20 years, you don't take any person, put it on a chalkboard and read it and give it meaning. You read it in context. The context here of the certificate, before you get to the background, which I will show you, that even that is against the first respondent. The certificate tells you that the charge is particularized people. Firstly. And recall that there could be more than Mr. Downer who disclosed confidential information without the authority of the NDP. So that might be a potential any person. But the way they help you understand who it relates to is they tell you the charge is contravening Section 417, firstly, and that crime, that contravention was committed on 9 August 2021. So you would have to find that the president was an accessory after the fact on 9 August 2021, and therefore this certificate covers it.
Well, we've got your point.
Yes, and the chronology says no.
You say any person has its own problems, but assuming it could include the applicant,
Yes.
The DPP has identified a time, place, and offence
Yes.
which can't relate to what has been alleged in the summons. That's your point.
Which they say in their answering affidavit. They say that the alleged offence of accessory after the fact occurred after 25 August 2021. So they just place it outside of the certificate on their own version.
Well, accepting for the moment your proposition on that, why can't the noli prosequi be read purposefully to implicitly include any person who was involved, let me use that as a neutral word, without going to the petty bureaucratic detail of having to spell out other dates and other competent verdicts on what is the principal crime. Seems to me that's the thrust of the first respondent's case.
Yes.
Is that it's a petty interpretation you make of the noli. to treat it in an unduly literalist fashion.
Yes. So there are 2 points to make. Is my lord, the question put to me, Justice Sutherland, is a sound one, but it will still be limited by the other contents of the certificate. So if any person, yes, involved in the matter, but involved as at 9 August 2021. You can't have any other person involved on the 25th of August 2021. That's the first point. But the second and more fundamental point is that the reason why one places a strict meaning to a non-prosecutor, it's the kind of power that it unleashes against a private citizen in the hands of another private citizen. You are now exposed to potential harassment by a private party who may be motivated by private interests in proceeding with the private prosecution.
Well, that may be so. That may be so, but let's just look at the Nolly more carefully. Can it plausibly be argued that the applicant is not implicated in the crime of 9 August, notwithstanding the fact that the actus reus of which he is accused to have perpetrated occurred at a later time?
Yes, he can't be accused of crime. Being involved in 9 August, he was not even aware of the commission of the crime on the 9th of August. And the commission of that crime was completed at that time. The only time he becomes informed of this is in the letter of Mr. Zuma of the 21st of August, asking him to investigate. Even the investigation is about particular matters. It's to investigate how, as he puts it, to investigate the ethics of the conduct of these prosecutors or officers of the court. And what the president does on the 25th of August, he doesn't ignore this. He says, he writes back to the president, to Mr. Zuma, and says, this is a very serious matter. I'm referring this to the Minister of Justice because it is the Minister of Justice that is responsible, that they have oversight, jurisdictional authority over the ADA. And I'm referring it to the LBC because you are also implicating professionals in private practice. So the president does something. Immediately, in part B, there will be argument about whether you can ever get a conviction when the president took steps of that kind. And remember, the president is not an authority that investigates crime under our constitution. Can you imagine if any minister can receive a request to investigate crime and they're eavesdropping in your telephone calls and investigating crime? They are authorities that the constitution says are law enforcement agencies that investigate crime. And this is a person who was himself a president. You know, even as president, he couldn't investigate crimes. How could he say that he asked the president to investigate crime? And when the president took steps, that in the taking of those steps, just because there hasn't been an outcome, the president is an accessory after effect or has defeated the ends of justice.
All right, we've got the point.
And the second point related to that,
I'm sorry to interrupt you, carry on.
Is that there is something unsound in the request if it is to investigate a crime. Because this very crime is before the criminal courts. They're prosecuting Mr. Downer and they're prosecuting Ms. Moore. How does the president, in parallel to the courts, investigate the crime? That's just unsound. It's unsound, it can never constitute a crime. And it's the same kind of reasoning the Constitutional Court has said about the exercise of powers by the public protector.
So you've got these several criticisms which will be the subject matter of Part B.
Yes.
You say that there's enough plausibility in it to afford you an opportunity to be heard then.
Yes.
And we should interrupt the prosecution in the meantime.
Yes, that's what we're saying. We're not saying determine finally that we are right. We're saying that on a prima facie level, there is. And just to understand the context I just submitted, in the heads of argument for the first respondent at page 011, page 112, in paragraph 42, they rely on the statements that were presented to the DPP to show that the president is also a suspect. But all that it says, you will see that what it says, they say in paragraph 42, they quote from a police affidavit which is saying that is proof that the president was mentioned in the affidavits. And it says, agreed by all of the above, on the 21 October 2022, the first respondent made a criminal complaint at the Peter Marisburg police station. And the chronology starts from behind, and the court will be there. He submitted the detailed affidavit setting out the background. That affidavit he attached, among others, the letter he had written to the president and his response. The following is said in the police affidavit, which forms part of the police document. He says the alleged conduct also forms part of a separate investigation which are conducted by the President of the Republic of South Africa, Mr. Ramaphosa. The relevant complaint letter written to President Ramaphosa and his response form part of the full papers in the application, which are ought to supplement my plea.
Well, that's what paragraph 17 and 18.
Yeah.
Why do you say that isn't sufficient to bring the applicant within the ambit?
Because all it says to you is that the applicant is investigating. It's not saying we have a complaint against the applicant at all. It just says we've complained to the applicant to investigate. They're showing confidence in the applicant investigating. They're not complaining against the applicant, which would form the subject matter of the charge. So that's really the point on the knowledge.
Mr. Manager, just while you are there, and I know that my brother has told us that we shouldn't traverse or even trespass on the merits. Is it possible for an official of the state to be charged criminally, that is, for not doing anything about a complaint?
We think it's not a crime, and that we will submit in part B, that this is a frivolous prosecution. Even if the president would be guilty of not performing his constitutional obligations diligently, and there's a section in the Constitution, 239 or 238 or that sort, we could complain about that. But you can't criminally prosecute him for failing to perform his functions. I think the entire government would probably be involved.
Thank you, sir.
I retract that in relation to the entire government.
Well, we're all concerned with that when the lights go out.
And the point, we simply you just take a quick peek as the Constitutional Court says in Uganda, and you will see that our complaints are valid. If our complaints are valid at a prima facie level, it means that there was no knowledge, valid knowledge that was presented to the registrar to issue a summons. And a valid knowledge is a prerequisite for the summons. So there's no private, valid, legally sound private prosecution.
Well, thank you. It's time for you to wrap up, Mr. Manichi.
So in relation to the requirements, there's a clear right. I know the court is not interested in this security, but if you do get into that and look at Munanda, that's the clearest admission of a breach of the CBA. But there is a prima facie breach in respect of the money certificate in the summons. And there is no alternative remedy. Balance of convenience favor the applicant. Mr. Zuma, if he succeeds in Pakistan, will continue with his private prosecution. He will suffer no prejudice. And so we submit as a case made out for relief. The outer principle doesn't apply as regards Mr. Zuma. He's not a public official performing public functions or exercising statutory powers. He's just taking advantage of a benefit that the statute creates for him to prosecute another private citizen. So we submit, we come home on the security test. In any event, if this was an exceptional case, this is an exceptional case, because on the face of it, the certificate is clearly not applied to the president, and he must be prosecuted unlawfully before and the court should step in to prevent the injustice from occurring. So those are our submissions, and what we will ask in the notice of motion is to ask for prayer 2.1 just against the first respondent, and prayer 2.2 to the extent that the court finds it necessary to go that far. We submit that once 2.1 is granted, criminal prosecution can proceed, and we don't specifically give an order excusing the president, and we only ask for costs on participating business and so on.
Is there any reason why the cost shouldn't be reserved for the Part B? You decided.
It's in the court's discretion.
Thank you, Mr. Manichi. We'll take a brief adjournment now and come back. It's the court will resume again at 11:45.
For my support.
to the court in narrowing the issues along the lines that have almost defined themselves. And even at the risk of not going to some of my favorite parts of the case. So what I propose to do, Justices, is, and I accept what the presiding judge was saying, that some of these things overlap. Some of the requirements for interdict also get into the points in limine. But with that rider, I will try to demarcate my presentation to deal with the preliminary points and then come to the merits, accepting that there are those overlaps. In doing so, and we must all apologize for barraging the court with so much paper over such a short space of time. But in doing so, I'm assuming that the lordships have read my heads of argument.
Yes.
So again, I'm not going to go chapter and verse. I'll go broad brush approach. As it happens, we also have prepared a bundle of authorities. I don't know if it was handed up.
Yes, it has been handed up. Thank you.
I also will try as much as possible not to go there, but for your lordships for your lordships edification when the time comes. What have we really got here? We have, as presiding judge has explained, an urgent application for an interim interdict. And that seems to be lost in what my learned friend's explanation of what this court is seized with. There is a big difference between what will or will not happen in Part B. And the court has been at pains to make us appreciate that. Save for, obviously, the extent to which we have to reach the Part B merits for purposes, for example, of prospects of success and so on. But these are two separate cases. So when we talk about jurisdiction, for example, my lords, we are talking about whether this court has got the power and wherewithal, to use my learned friend's words, to grant an interim urgent interdict, not Part B. We will have that debate sufficiently in Part B, and for the record, our position is that even the Part B court does not have jurisdiction. But that's not the debate for today. So when my learned friend relies on cases like Nandalal, he's making that fundamental mistake. Nandalal and all the cases he refers to are, to use the language of this case, Part B. So all those considerations that were done there, they were Part B considerations, which may or may be good or not bad. The certificate is defective and what have you. All those things would be dealt with there. Does the prosecutor have an interest, peculiar interest and all that? Those niceties will be debated sufficiently in Part B as they were in Nandalal's case. Here, we have a very simple task, which is I'm going to try and frame it for excluding what the court has excluded. Whether A, as I've just said, this court has jurisdiction to entertain this Part A application. Subsidiary to that, and let me just, for the sake, because we're an urgent court, I'll make a statement which will also cut down what I was going to say about jurisdiction. I am prepared, Justices, and I must say this carefully because I don't want you to bite me when we get to Part B. I am prepared, for the sake of this particular hearing, specifically, to accept provisionally think I've done all the insurance now too. To accept provisionally that my learned friend, Mr. Maineche, is correct in the following sense. That if this court, or rather, if there is abuse of the court and all the things that they will deal with in Part B, and even the ones that they deal with here.
So the abuse of the court or the abuse of the process?
The abuse of the process, the bad motive, or whatever. Mr. Maneche's point, which I appreciate, on the issue of security, and I know that the security issue, as I've said, is the best way I could put it is provisionally condoned. And so is the other issue about the commission of oaths. I think that one is condoned totally for the purposes of this. Now, but I just want to talk about jurisdiction. I'm saying the double-edged concession that I want to make just to save time is that if this court has the right or power to dismiss this application on the grounds that they allege, for example, let's assume the issue of security was still there, or Section 7, whatever. From a jurisdiction point of view, then you'd have to say the court has jurisdiction. Now, I'll refer the court with, again, broadly, because it's one of the cases here, but I'm sure the court is familiar with it. One of the best written judgments on jurisdiction is the case of Makanya versus University of Zululand. It's a judgment of Justice Nugent in the SCA. There are other cases, Taba in the Concord and so on, but still my personal favorite is the Makanya case. Because in that case, it is made clear, the following proposition is made, that everybody always makes this mistake when there's a jurisdiction debate of saying, no, my case is good, and therefore the court has jurisdiction. And Newton J.A. goes for about 3 pages explaining how that logic should not work. Because if the court has jurisdiction, it has jurisdiction to uphold the claim, but it also has jurisdiction to dismiss it. And that's what most people always miss. So from that standpoint, I would say that, as I said, provisionally, this court has the power to at least dismiss some of these issues. But, and yet this is where the double edge comes.
But Mr. Mpofu, if you say it has the power to dismiss, I would take it that it also has the power to entertain.
No, that's the point I'm making.
Okay.
That's the point I'm making. That whole logic in the Makanya case is that you cannot say a court doesn't have jurisdiction just because the case is weak, for example. Because that's a different thing about whether the case is weak or strong. That goes to the merits. It's a complicated debate, but in the urgent court, I won't be able to deal with it. But the point I want to make, Justice Mulafay, is that the rider, which my learned friend Mr. Maineche will not like, is this. Even if, strictly speaking, and we make that point in our heads, even if, strictly speaking, therefore this court has the power to entertain, i.e. to dismiss or uphold. But this court is not, or our courts have said that they are not inclined to entertain so-called preliminary litigation, which this is a classical case of. And that, for that proposition, the court in any event would, just from that standpoint, dismiss this application. Because, and I just want to read from the Moyo case, because we really anchor this argument, this second leg of my argument on the Moyo case. In my respectful submission, the dicta in that matter of His Lordship Mr. Justice Wallace JA are completely dispositive of this matter on the secondary level. In other words, to the extent that is preliminary litigation, it should not be countenanced for that reason specifically. Or if I'm wrong that it should not be countenanced at all or entertained, let's use the word entertained, then it should certainly not be condoned in the sense of promoted or upheld. This is captured in two parts of the Moyo case. The first one is what we've put as our preamble, where His Lordship Mr. Justice Wallace said, the appellants do not seek to impugn provisions of the CPA in any way, yet they are seeking to assert their fair trial rights before a civil court. You remember that under trial, the prima facie rights, some of the rights that they list there are fair trial rights under Section 35. That should give pause for thought, and I'm not asking for anything more than that. And then he asked the following rhetorical question. Why are issues germane only in the context of criminal proceedings, being canvassed and determined in civil proceedings, and not in the constitutionally compliant forum and in accordance with the constitutionally compliant statute provided for adjudication of criminal cases? I said that question is rhetorical as asked by Wallace J.A. because the answer there is obvious, that a civil court, let alone urgent motion court, should not even start to usurp the powers of the criminal court. And as I say, I don't want to go as far as to say it has no power to do so. But I'm simply saying it's something that should be done, as the cases say, in the most extreme exceptional circumstances. Why is that? Because we're going to be caught in what was almost happening here, where we now have to look at the merits of the elements of the crime, competent verdicts, and what have you. All of those issues are going to be canvassed in the trial. No civil court has a right to entertain those. Forget about urgency for now. Because, just finish this thought, Justice Funake. The civil court is not capable of making, not capable doesn't mean it in the personal sense. The minute you start wearing red robes, suddenly you are capable. So it's not, I don't mean that in the personal sense. But the civil court is not capable to make all the nuanced assessments that are made when you're wearing your red robes. In other words, wearing your criminal court mind, so to speak. Where the standard is different, the test is different, the balance of probabilities, the entire thing is just completely different.
No, I think I have your point.
Yes.
I mean, the way I understand it is this. You're saying it's a proper distinction to make between matters which should be subjected to the criminal process and others which should be subjected to the civil process. And one should not cross-contaminate unless there's some truly exceptional circumstance. That's your point.
Yes. And pregnant in that is what I call the subtle concession, to say, surely, Justice Sutherland, there might be circumstances, we can all imagine circumstances where there are people dying out there, and then you come to court and they say, no, I'm wearing a black robe. Surely that would but nothing of that sort is happening here. What we have here is a simple pedestrian charge. A person who has been charged, who must just come to court and say their piece. But this one, because they can afford it, even has another avenue in Part B to say their piece.
But I would assume, Mr. Mpofu, in that conceptual analysis that you're proposing, that one of the issues, if you take the pedestrian case and the other cases you're referring to, I would assume consideration would have to be given to the issues relating to freedom, liberty, and all those human rights, or the rights in the bill. Yes.
Yes and no, Justice Timothy. Yes, in the sense that in the catastrophic example that I was imagining, obviously that applicant will be saying, court, stop everything, I don't even have papers, but give me this urgent relief because people are dying in the street. Yes, of course, for the court to pause and drop its urgent role for that, it must be informed by the fact that the rights of those people are being affected and the one before it. That I'm prepared to concede. But in this particular case, coming back to this particular case, we must then look and inspect what are the rights that are indeed being asserted here. And I'll group them into three. One is they talk about the rights to dignity. And then they talk about rights to reputation. And then they talk about this nebulous part that relates to him as the president. In other words, they say the public interest and so on. And I will show, and that goes to an issue that was raised by Justice Sinyati, so that let me just get rid of that out of the way very quickly. He posed the question to my learned friend, can a public office bearer be charged criminally? But that goes to the...
For not doing his work.
Yes, for not doing his work. Fair enough. The answer is a big yes, Justice Sinyati, in the following manner. Remember, one of the objections we raise here is about locus standi. And that is not a trivial matter. It is whether this applicant, this one who's here in front of you, is the President of the Republic of South Africa. That applicant is not the same person as the accused in legal terms. The accused is Mr. Cyril Ramaphosa. There is a reason why he was indicted in that capacity. There is a reason why he was, the indictment, I can't remember the page now, says Jacob Zuma, private prosecutor, versus Cyril Ramaphosa, the accused. It says nothing about any president. Now, of course, at the trial, it might turn out that there's a whole complicated debate about whether there can be vicarious liability in this context and so on. Those are all niceties that will be debated there. By the way, there's no vicarious liability for public officials in the sense that my learned friends want to allege, but I'll save that for part B. The point is this: there is a misalignment, what in outer was called a misalignment, between this applicant who's in front of you, the president of the country, and the accused person. So the locus standi arises in that sense. Can the president come here to assert the rights of Mr. Ramaphosa, who lives in some place which we will not mention for security reasons? Can he do that? That's the first issue. If he cannot, and we have gone so far as to say the best he could have done, if I was him at least, would have to say, I'm coming here as the president, but I'm also citing Mr. Ramaphosa, the accused. Then we could have had a different debate. But no, they decided to cut out the accused completely and come to court as the president. That is why the question from Justice Nyati is quite legitimate, because what you have in front of you is not the accused person, but a public official. But let me then answer the question. The answer lies in this simple example of Justice Nyati. If I go out of here, I drive here, and a traffic policeman wearing a uniform on duty, all the requirements, ask me for a bribe, I have the right to charge that policeman if the NPA refuses to do so. As Mr. Temba Chabalala, that situation must not be confused with the situation where in the course and scope and so on, there might be civil vicarious liability. We're talking criminal, and this is again the danger with this, because now we have to be talking criminal concepts in the civil court. And there is a subtle philosophical clash. So, of course, nobody can say, no, don't charge that traffic policeman, charge the Minister of Transport, because he was wearing a uniform, he was on duty. There's no doubt about it, it's common cause. What am I saying? Criminal liability, by definition, attaches to an individual. There are exceptions. Section 332, I think, of the Criminal Procedure Act creates one of those exceptions, where you can charge a company and so on, and therefore there's kind of pseudo vicarious liability. But that does not apply here. So the answer is there's no public official who has been charged, rightly or wrongly. That will be
Mr. Mpofu, as I understood the question of my brother, it related more to the question of failure to perform your function.
Yes.
Not so much the example you're giving, it's a clear contravention of the law. And you can then say you have been corrupt and therefore we charge. But here, I think the question, if I understood it, was to say, can you charge a public official for failing to perform their duties?
Fair enough. Thank you, Justice Muthe, for that. The answer is even a bigger yes. Because that traffic officer I'm talking about will be failing to do his duty is to ensure that if I've exceeded the speed limit, I get a ticket, right? The failure to do that duty is him not doing that and asking me for a bribe. Right. So you can't have that artificial distinction. The point I'm simply making, forget the examples. The point I'm making is that it is in our criminal law jurisprudence, it is quite permitted, and maybe even higher than that, to charge a public official as a person for a transgression which they have committed qua public official. That's why we have something called the PRECA, Prevention of Corruption Act. Because a person charged under PRECA can't say, no, but when I did that tender deal there, I was doing it, I was the minister. It was not me as Minister XYZ. So let's put that aside and put it to bed and come back to the real issue here. There are three categories of complaints, justices. One is the one that deals with Section 9, the security, and I've said that is off the table. Oops. We can charge people for that.
We'll pause for a moment while Eskom's telegram is read.
That's correct.
The recording device will take a little while to boot up, but let's not wait on that. Carry on, Mr. Fulton.
Yes, thank you, Malas. Let me just wrap up so that I don't have to come back to this local standing point. In our heads of argument, we refer to the case of giant concerts, which the lordships are familiar with, where it was said that this type of relief, even in Part B, must be, I'm paraphrasing, required by the right person in the right proceeding. So are these the right proceedings? We say no, because it's an interim relief. But we say, is it the right person? And again, we say no. And we've made the point in the heads to say that this is not a trivial matter. It's a Section 38 of the Constitution matter. The President is quite entitled to come to this court and say, I'm coming here in my personal capacity in terms of Section 38A of the Constitution, but I'm also coming in terms of Section 38D in the public interest. And in that sense, I'm coming now as the President of the country. He would be entitled to do that, but he has not done anything of the sort. He has elected to come here under Section 38A in what is called by the Constitutional Court in Giant Concerts, own interest standing. And in our respectful submission, elects standing in that capacity. Because of the misalignment of what I've explained, but also because the own interest. And you see, the danger of not addressing an issue like this, even in urgent court, is that it can be fudged. So, in one paragraph, they said, oh, well, you know, the rand is going to fall because I'm the President and I have to attend to matters of the state, fair enough. The next paragraph, my reputation now as a dignity as a person is also affected. But he is asserting that as a prima facie right for this relief. And then the one that takes the cake, he claims BioWatch at the end. I mean, that's just such conceptual confusion, because you cannot claim BioWatch to benefit from BioWatch if you indeed come here as an organ of state. But if you've come here as an individual accused person, of course you can claim BioWatch. But as I say, those niceties will be debated in Part B.
If I can sum up as I understand your proposition, the person who is confronted with a private prosecution is entitled to challenge it, but must acknowledge that the proper place to make such challenges is within the criminal law process, and should not seek to obtain some unfair advantage by preempting the provisions of the criminal law, which inter alia provide in section 108 and 6H to raise these exact issues at the time when the matter is called, and to burden a court with those same questions.
Absolutely.
It's true there are some old cases and some more recent cases which say so, but they have not applied their minds to the proposition which you've advanced.
Absolutely.
And therefore that's res novus.
To that extent, it's res novus. That's correct. That sums up my submission on which straddles, as you correctly put it, Justice Sutherland, straddles this issue of not so much jurisdiction, but whether it's desirable to do so. But it also straddles the merits of, in other words, in the context of alternative remedies.
Yes.
Yeah. So all those are disentitling features of this case. To answer the only simple question before this court, which is, should an urgent interim interdict be granted in these circumstances? Now,
So it must follow from that proposition that it's your contention that even if it were to be assumed that the applicant would suffer anything properly called harm, it cannot be material harm.
absolutely. It cannot be in two senses, Justice Sutherland. In the sense that you alluded to my learned friend. You can't come to court and say, agent court, please stop, order that the Johannesburg City Council must provide me with water, because I opened my tap and there was no water. Of course, that affects your rights. I mean, who can debate that? But what is this extra thing that makes you, the applicant, to come to court? Because if the harm, quote unquote, that you suffer is that which is suffered by all of us, well, tough luck. And the point is simply that any person in this country who is accused of a crime, rightly or wrongly, whether they will be acquitted or whatever is in the end, have to suffer the inconvenience, let's call it that, of appearing in court, and the inconvenience of putting their defense, and the inconvenience of raising all manner of technical issues that they might want to raise, good, bad, and indifferent. So where is this harm? And my learned friend talks about the so-called, we were actively wanting to refrain from getting into this thing about the ANC conference and step-aside rule and what have you. But they keep on forcing it on us because they raise it in their correspondence, they raise it in their papers. I have one thing and one thing only to say about it. The entire step-aside debate is actually evidence that this court should not grant this relief. Why? Because on their own version, the so-called step-aside rule kicks in, so the harm related to the step-aside rule kicks in once you are charged. Right? So that has happened already on the 15th of December 2022. So let's assume for a minute this court grants this relief that is being asked for here. The step-aside rule will still be operational, because the only two things that can get the president or Mr. Ramaphosa out of that jeopardy, two are: one, that the summons and the charges are set aside in Part B, not here. Two, that the public prosecutor, the private prosecutor withdraws the whole thing. Apart from those two things, if he is, I don't know if he is vulnerable to a step-aside rule, then he will be, even if you grant this relief. Because the charges will still be there until the day they are set aside, expeditious, or rather on an expedited date or whatever. But not, this court is incapable of getting him out of that jeopardy. And therefore, that harm is, as it was said in giant concerts, it's hypothetical, academic, but it's actually non-existent, that harm. It's manufactured and contrived just to create atmosphere.
So in other words, the harm is there already.
Yeah.
Whatever this court says, the harm is there.
Absolutely.
It may have not yet materialized.
But it's there.
But it's there.
Yes, and the way we understand it, Justice Mulafe, is that, to be fair to my learned friend, they are also saying that it's potential harm in that extent. In other words, it's what I call the vulnerability. And I'm saying that vulnerability kicked in on the 15th of what you call it? December, yes. And whether, let's even go to the ridiculous extent of saying this court could conceivably impose on the criminal court next week that the accused must not appear. I mean, what is that? But let's assume that the court could do that. Even if that were to happen, that harm is still there. Because the harm doesn't, the step-aside rule doesn't say you must step aside if you appear in court. It says you must step aside if you are charged. So, on which court can then grant an interim interdict against harm that is going to be there whether you grant the interdict or whether you don't. That alone is an example of the abuse. And Mr. Manache and I were incidentally in a case where we debated this. And we both relied on the case of Erdex that I see he has cited here. It's a 1986 case. And I won't bore the court with details. But in that case, the point of contention was this. Can somebody, and I think it was the president at the day, somebody who is not a party to some controversy, without those two parties come to court and say, I want an interdict that you must interdict that controversy between those two people. And unfortunately, the case didn't go as far as Part B. But it's the same point that we're making here, as to what there must be what is called congruency. Let me start here. An interdict, any interdict, final or interim, is what is known as an extraordinary remedy. It's not a remedy that you just get given. It's an extraordinary remedy for emergencies. Now, how are you going to get remedy? Let's take it literal, remedy as medicine. So, if you are going to give a remedy that doesn't align to the ailment, I have a problem with my stomach, and you give me tablets for headache. Then what's the point? What's the point of this court then addressing some harm that is not related to what we are busy with here? But before the lights went out, I wanted to say this, to try and reduce it to this. We all accept for now that the so-called defects to do with security and so on are off the table, or as I say, provisionally condoned. We all accept, I hope, that the other complaints about peculiar interest and so on will be dealt with in Part B. I think that was one of the statements made in Mandela. So we're left with only one issue, and that is the issue that the court debated with my learned friend. That's the issue of the certificate. So all these things, their rights, their harm, this, that, and the other, turn on this issue. And I'm going to address it now, Justice Bleffer.
Yes. No, I just going to say, before you move from that point,
Yes.
They're not only relying on the step aside rule as an aspect of harm.
Yes.
They also raise the issue of liberty and freedom of movement and all those. That's another aspect related to.
Yes.
Yes.
Yes, Justice. And this is one that you and I discussed earlier about whether, and I considered that if there is a threat to freedom in that exaggerated example I was making, then the court can say we're closing the doors. In fact, that's the essence of the statement made in the Tint case. Because in the Tint case, Mr. Zuma, ironically, and a company called Thales were saying, no, there are these and these defects, and the warrant is defective, and so on and so on. And the court said, we are totally against preliminary litigation because of it's burdensome not only to the accused person but also to the prosecution for obvious reasons, which I don't have to spell out to this court. But to answer your question directly, Justice Molofi, the court said, but you cannot close the doors of the court completely. And I acknowledge that. The concession I made at the beginning was informed by that statement. So the Tint formulation, all I'm saying is that even on the Tint formulation, which is not the one that says we're closing the door, there's no jurisdiction, let's all go home. Even on that formulation, they are still outside. And I say on the Moyo pronouncements, there are even more reasons for this court not to grant this. And if you
as we debated earlier, and your reference to the Moyo case, if we find that indeed the appearance at the criminal court on the 19th is going to impact on the applicant's freedoms and liberty, you would concede that it's a factor to take into account in weighing whether or not to grant the interim interdict on an urgent basis.
Yes, if you put it like that, if you say a factor, I can't quibble with that. But the point I'm making, Justice Mlahle, is this: let's say, for example, that then would answer the question of prima facie right, for argument's sake. But what I've just addressed around that very same issue is, what about harm? Where's the harm?
Yes, you've dealt with that point.
So we know that these four requirements all interact, they all interrelate here. So it's no use for me to come and say, I have a right to this, I have a right to that. We all have a right to that. That's what Justice Museneke said in DCJ in Outer. You can't come to court and say, I have a right, for example, to review. We all have a right to review. Section 33 says everyone has a right to review. But you must then marry that right to some harm which must be remedied by the extraordinary relief of an interim interdict. That's the law, not whether we have a right or not. So I'm prepared, for the sake of argument, because we are in urgent court, to say yes. Of course, if he's going to come to court for 30 minutes, which is probably what it's going to be, for the matter to be remanded, as it always happens on the first appearance. For that 30 minutes, theoretically, his freedom is curtailed. But so is the freedom on that very same day. There will be hundreds of thousands of people in this country who are appearing in courts of law. Half of them are guilty, half of them are innocent.
But sorry, Mr. Mpofu, to just hold on this, just for my own clarity.
Yeah.
If we say that, accept that there is invasion of the freedom here, and I'll use just the freedom.
For 30 minutes. Yeah.
Yes, for 30 minutes. And that interference, we know, in as far as freedoms, particularly of liberty and all that, it's fundamental to our constitution.
Of course.
And therefore, what would be the remedy once that has happened? It may be for 30 minutes, it may be for 20 minutes. Yeah. But if it's an invasion of the constitutional right, that's quite fundamental, and the court can't ignore that.
Lord, yes. An interdict is not something that is meant to cure the violation of rights per se, right? If they were here to ask for a declarator, for example, to say, court, please declare that 30 minutes or 30 seconds, for that period, our rights of movement will be curtailed. Of course, we wouldn't oppose it because it's obvious. But this is not an application for a declarator. This is an application for an interdict, which says that not only is that right going to be curtailed for that 30 minutes, but you, court, must consider the other elements around that right, such that you feel bold enough to stop all the other litigants who have been waiting for months and months for their cases to be heard, number one. And two, to remedy that 30-minute harm. Why? Why must it be remedied when it's not remedied for me and for him and for her and for all other people who are facing the same calamity? The answer is the one that they don't want to come to, which is that because he is the president of the country. And our law does not countenance that. There are countries in this world, and I think the United States is one of them, where a sitting president is not charged, and some people want to sit in that office for as long as they can, so as to avoid that. But mercifully, we are not one of them. Here we have something called Section 9(1) of the Constitution, which says all are equal before the law. Whether you are the president or the former president, for that matter, all should be equal before the law. It can be that that principle only gets applied when one of those people, whether it's the former president or whatever, has to be prosecuted. But we forget it when it's another person. All are equal before the law. So Mr. Kize or Chabalala that I postulated and Mr. Ramaphosa are in exactly the same position in the eyes of our law, qua accused persons. Now, quickly, again, so that I don't have to go to do this, let me, since you've raised it indirectly, Justice Ndafini, let me talk about the question of alternative remedies. In our respectful submission, that is the one factor that is impossible to overcome by the other side. Because there's Section 106. There's, if they want to talk about the title to prosecute. If they want to talk about the appearance or non-appearance, there's Section 158 of the Constitution, which says that all criminal proceedings must happen in the presence of the accused. If the Section 159, which is an escape clause, in fact, ironically, this whole thing started like that. This medical information that was disclosed to journalists and so on and so on, all that happened in the context of, in 2021, under COVID provisions, when the private prosecutor was imprisoned. And we simply wanted for him not to be present in court for all those reasons. And the NPA said, no, if you want that, you must do an application, because you know the law, you have to be present. And we did. It was in the course of that application that that brought us here. So there's Section 55, I think, of the CPA, which says that if you have a summons against you, whatever you think of them, if you have a document, a summons or summonses, as they say, and you don't appear in court, a warrant for your arrest must be issued. That's how much the law views that transgression. Now they're saying this court must authorize that kind of thing. And again, it's 55(1). Any accused who is 18 years or older and who summons under Section 54 to appear in a criminal proceedings and who fails to appear at the place or on the date at the time specified in the summons or fails to remain in attendance in such proceedings shall be guilty of an offence and liable to the punishment prescribed under subsection 2. All courts are familiar with this. And again, the irony of ironies, a similar thing happened to former President Zuma. He was, I think, in Cuba for some medical attention and therefore did not appear. And Justice Pillay, the same judge who decided the Nandalal case, said, I don't care. I want a certificate. And the certificate was ended up and she was not happy with it. And she said, I'm issuing a warrant of arrest. I'm not saying he's not sick. I'm not saying he's not being attended. But under Section 54, if he's not here today, I have to issue a warrant of arrest. And we all know whatever then happens on the coming back, you then produce and so on. And then so that's how our law, how strongly our law views the non-appearance of an accused. And this court is being asked, with no exceptional circumstances, to order such a thing. The breach of sections 158 and 55 of the, which is punishable by imprisonment. So the alternative remedies are countless the remedies in Part B, and then there are the remedies in the criminal court context. In the criminal court context, which we have spelled out. I don't want to go there. But I dare say that the issue of alternative remedies is one that is completely insurmountable on these facts. Let me, before I get into trouble with time, please just address, I'll come back to other issues, but I want to address what I, in my respectful submission, view as the only issue on which this so-called interdict is now pegged. And that also goes back to an issue which was raised by Justice Sinyatsi, where he said, please help me. So I wanted to say that, well, I will help you when my turn comes. The certificate debate is just, to call it a contrivance would be very charitable. Firstly, we are given hyperbole. It says, any person. No, I mean, how could you, what are these people smoking? How could you have a certificate that just says any person? I can just go to the taxi rank and grab anybody and tell them, no, I've got another prosecutor for you. Now, what is that? The reality, all lawyers know that documents are not read like that. You can't say any person and then run around the block. You must read the full thing, which one of the justices said. On the document itself, it says, and I'm paraphrasing, I'll steal or borrow Justice Sutherland's formulation. Let's forget the niceties of that interpretation. What that Nolo prosecute says is that it is against all those people who are involved in the matter. So suddenly from 60 million inhabitants, we're down to 10 or so. But here's the catch, which makes it even more ridiculous to assail the certificate on the basis of the width, the alleged width thereof. The NPA inadvertently, improperly, probably criminally, in an effort to shield the president, put him under the bus. Because they're wrong on the fact that he's not mentioned in the affidavit. I mean, that's demonstrably clear. Everyone, I think my learned friend has even considered it now. He was reading paragraph 17 himself, where the president is mentioned. So we don't need to go to that debate. They're just wrong. They're completely wrong. There's no wonder in the affidavit that was filed on Monday for the NPA that there's not a word that says we stand by our statement that we made in public, because it's false. But where they are correct is on the legal interpretation. And all we can say to them is thank you very much. They say the knowledge certificates, I'm reading from 001-217. That's the knowledge of, or rather the media release from the NPA. The knowledge certificates, listen to this, apply to any persons who are specifically mentioned in the document. That is the NPA now, the authors of the knowledge prosecution certificate. They say it applies to any person who are persons who are specifically mentioned in the document. So again, we've given a list of those persons in our heads. There's 6 people. So from this alarmist thing, we're now into a pool of 6 people. So the only question really around the certificate, to be honest, before this court, is whether accepting the obvious interpretation of the certificate on its face, which is that it's for those who are involved. And even more, if we are not happy with that, accepting its interpretation by its own authors. It's a very simple exercise now. If the knowledge certificate applies to persons who are specifically mentioned in the docket, we just go to the docket and look. And we will find the name of one, Mr. Cyril Ramaphosa, mentioned. End of the case on the certificate. Because on their own version, it applies to him. Is he guilty? I don't know. All those things will be debated in the trial court. But does this knowledge prosecutor apply to him? Yes, yes, and yes. And if it does, and if that is indeed the only pivot upon which the so-called interdict is anchored, that's the end of it. That's the end of it. But there's more. Justice Sinyati asked the issue about the so-called timelines, another red herring. This one is embarrassing to have to explain this to lawyers. My learned friends, we explain this to them ad nauseum in the papers, and I think even in the correspondence, but they just refuse to deal with it. There is no issue about the date, right? We are not, amateurs here. We could not come and say the President or Mr. Ramaphosa committed a crime on the 9th, on Women's Day, the 9th of August, when indeed, on the version of the private prosecutor, he was only informed of the crime, as Mr. Malnecha puts it, on the 21st of August. It's a no-brainer. The point that is being made, to even articulate that point means a person doesn't understand the meaning of the crime of accessory after the fact. Because accessory after the fact, that's why it's a crime that has that long name for a reason. After the fact. So the question is the 21st of August after the 9th of August? Yes or no? If it is after the 9th of August, then that's actually, as we say, it's a confession. What they want to present as a defense is actually a confession. Because it's a definitional element of accessoriness after the fact, that you can only discuss into that when the principal crime is completed. If the minute your participation is not after the fact or after the completion of the principal crime, then you are an accomplice. And that's the difference. It's lesson 1 in criminal law 1, participation in crimes. There are 3 types of participant. One is called the perpetrator, the second one is called the accomplice, the third one is called the accessory after the fact. And all of them are defined by, not just by levels of participation, but by the time of involvement. So here's every textbook that I've ever read makes the following example to say what is an accessory after the fact. Myself and my learned juniors, we go and rob a bank on the 9th of August. Let's make it easy. We rob the bank, we take the money, we put it in the boot. Then on the 21st of August, we then go to my learned juniors behind me. And we say, you know what? We were worried that too many traffic police here. We robbed the bank, we tell them. We robbed the bank on the 9th of August. Please help us to hide the money. They hide the money. Criminal law 101, they cannot be charged for bank robbery as perpetrators. These ones who went with me can be charged with me as accomplices. But these ones can only be charged as accessories after the fact. Why? Because after the crime was completed, the mens rea element is their conduct will be not mens rea, the actus reus is their assisting, aiding the bank robbers to conceal or to escape justice. It's as simple as that. So if we can show that no, actually they were there on the 9th of August, then we cannot charge them as accessories after the fact. So the date thing is just a red herring that is completely just a waste of time. The section, I think it's 257, section 257 of the Criminal Procedure Act falls under the heading competent verdicts. And section 256 deals with the theory of competent verdicts. And if I had time, if we were in part B, I would try to take an unfair advantage by quoting a judgment of Justice Sutherland on competent verdicts, but we don't have time for that. But then section 257, specifically the heading of section 257 is called accessory after the fact. And just indulge me for a minute. Let's start with 256 because that's where the thing. If the evidence in criminal proceeding does not prove the commission of the offense charged but proves an attempt to commit the offense or an attempt to commit any other offense of which an accused may be convicted, on the offense charged, the accused may be found guilty of the attempt or of that offense as the case may be such an offense. But very broadly, what that means is simply that if a particular accused, if one of the elements is missing, then you can it's a competent verdict to convict you for a lesser offense. But 257 is more direct. It says accessory after the fact. If the evidence in criminal proceedings does not prove the commission of the offense charged, but proves that the accused is guilty as an accessory after that offense, or any other offense of which he may be convicted on the offense charged, the accused may be found guilty as an accessory after that offense, as the case may be, such other offense, and shall, in the absence of any punishment expressly provided, be liable to punishment at the discretion of the court, provided that such punishment shall not exceed the punishment which may be imposed in respect of the offense. So, decode. There's something called the principal offense, and then there's the accessory liability. There's no such thing. A millennial friend says, well, let's forget the dates now. Here's the crime. The crime is defined in Section 41(6). Aha. The president, that crime is for members of the officials of the NPA. Therefore, Mr. Ramaphosa cannot be guilty of that. That's fallacious logic. Because that's exactly why the common law created this thing called accessory after the fact. It is to cater for those situations where the accessory does not meet one of the elements, such as working for the NPA. That's the whole purpose of the thing. And so then they say, okay, this is the best part. They say, look at the two certificates. The one is on page, I think 113, the other one is on page 166. And I asked my learner juniors to do the exercise of spot the difference. If you put those knowledge together, the one difference you will see is the one that Mr. Manager alluded to. That in the second one, the standard form that says suspect has been erased. Why is that? It is because the suspect or suspects in that certificate have been defined in the governing phrase. Any person who is involved in this matter, the state declines to prosecute. That's why if they had then put again suspect, then it would have been tautologous. It's because the suspect or suspects have been defined in the certificate itself, and it is any of those 6 persons that were listed. So this idea that there's something wrong with those certificates is completely baseless. And if I'm correct, with the greatest respect, that is the only basis for their belief. Then, I know it's converted logic, but I want to touch on quickly on the issue of urgency. And I take Mr. Manacha's point that, okay, well, we're here now, but it's easy for him to say that after he has hauled us out of our engagements, which have been bugging him about every day since for the past 10 days. The point is this really about urgency. You can't have your cake and eat it. You can't say my urgency derives from the fear of the step aside rule related to the ANC conference. And then you do nothing. The president even goes to say, I've never seen anything like that. If you go to the return of service, that summons was served, I think at 3 in the afternoon or something like that. He says, I went and consulted my lawyers on the same day, on the 15th. Very commendable. Why? Because in his mind, this was meant to disqualify him from standing as president of the ANC, which then would mean disqualifying as president of the country. That's serious business. I don't blame him. If he indeed perceived this thing to be threatening his job in the ANC and his job in the country, then he had every right to go in and consult his lawyers on the spot. But what does he then do? That's when he should have come here and say, I'm waking you up, urgent judge. It's 12 o'clock, I know it's 12 o'clock, but the conference is starting, the nominations are tomorrow, and these people have charged me frivolously or whatever. He doesn't do that. He doesn't do it on the 16th. He doesn't do it on the 17th when the nominations are there. Instead, he takes a contemptuous position that says he is entitled to ignore the summons. Our law books are littered with examples that show that you cannot do that. You can't ignore an outwardly valid administrative act, whatever you think of it. Justice Madlanga, we quoted that in the letter that we sent to them. Justice Madlanga said, the letter, our response of the 17th, I'll find it. I think the case was Magnificent Mind. Sorry, 170. 001 170 and 2. Letter we wrote to on the 17th to respond to the. I'll come back to that. Anyway, let me paraphrase it. But again, the court knows this. That what we know as the Odekral rule or the omnia pars mentur principle is meant exactly to deal with this situation. And it simply says, if there is an outwardly valid act, administrative act, you have to act on the basis that it is valid until it is set aside by a court of law. Elementary, it's called the Odekral principle, elementary principle of our law. But the part I was looking for, which we quoted in the letter, was where Justice Madlanga beautifully put why we have such a law. Because he says there will be so much chaos if we, sorry, 205, 001 205. Thank you, I'm in the friends, It's at 206. We quoted it. We were giving them free legal advice. We said that the president is legally entitled to ignore a legal document simply because it disputes its validity without taking any steps to set it aside. To your knowledge, that attitude flies in the face of the rule of law and the presumption omnia presumptur rite esse. In South Africa, this is known as the Odekral rule, in respect of which Madlanga J recently said in the Constitutional Court case of Magnificent Mile Trading versus Cillian, quote, the Odekral rule itself is informed by the rule of law. Imagine the specter of organs of state and private persons ignoring or giving heed to administrative action based on their view of its validity. The administrative and legal chaos that would ensue from that state of affairs is unthinkable. Indeed, chaos and not law would rule. But that was the advice we think that the president has given. No, you can ignore this thing. Now, this court must reward a person who takes that attitude for so many days, contemptuous to the rule of law, and say, well, we forgive you for not going to court for on the 15th, on the 16th, on the 17th, on the 18th, on the 19th, on the 20th, and on the 21st. And I'm pausing there for a reason, because I know the answer is going to be, no, but we wrote you a letter and we said you must withdraw this frivolous thing and so on. But we responded to the letter. Okay, let's say we forgive them until the 21st. Then we tell them we're not going to withdraw anything. You do what you have to do. Then 21st, 22nd, 23rd, 24th, 25th, 26th, then the 22nd, on a public holiday, we receive the payments. Agent, we want your notice to oppose tomorrow on the 28th. Now, if any court can sanction that kind of behavior, let's even assume for a minute that they had a strong case, which is definitely not the case. They would have a duty to explain two things. Why that undue delay? Number two, why is it that they may not get redress in due course? Now, and this, the next submission I'm going to make also touches on punitive costs, which we think should be paid here.
But the critical point in as far as the 2 points that you're making, Mr. Pofu, is the question of relief in due course.
Yes.
Because in as far as the delays are concerned, and I think in the re-agent court matters, the court has explained the approach that needs to be adopted in as far as the issue of delay is concerned. It can't per se disqualify an applicant in as far as the relief sought.
No, my lord, I'm sorry, that's not the case, with the greatest respect. The courts have said the exact opposite. The courts have said that a litigant who inexplicably delays coming to court, for that reason alone, is remiss to then want a preference in the agent court.
Even when he provides an explanation.
No, but that's the point I'm making.
That's the point.
If there's a, yes, of course, if there's a logical, no, of course, my lord. Yeah, okay. Sorry.
So then maybe we missed each other in a
Yes. No, we did. No, that's exactly the point I'm saying. There's no logical explanation. That's the crux of my submission. So, no, thank you, my lord. No, then we're on the same page. But I'm saying, I'm prepared, my lord, to say that, and we all have been in agent court, we know, and so have you more than us. We all know that even if you delay, in terms of the case of East Rock, if you give the explanation, it can be overlooked. Let's put it that way. However, the point I'm making is, again, it's this incremental submission I make. I say, okay, let's say we forgive the first delay and the second delay. Now, why is it that they cannot get relief in due course? There's no logical explanation given for that. I'm just trying to find the section on agency, but let me paraphrase. What they say is actually a blatant untruth. They say that we will not be able to receive relief in due course because by the time the Part B case happens, the criminal proceedings will be complete.
Did they say complete or commenced?
Complete. Or complete or completed. No, that was the retreat. Later, when we pointed it out, they said, well underway, whatever that means. They say complete. And we point out that that is a blatant lie. Banana Tunas will find it. Yes. Thank you. It was 0158. They said, in the circumstances, I will not be able to secure adequate redress in due course because by the time this matter is held in the ordinary course, prosecution will be well underway, if not complete. Now, I'm saying, who in their right mind, even the first year law student, knows that the first appearance is going to be a postponement. A case of this magnitude is not going to be complete. And quite frankly, we all know, just from our own experience, that what is likely to happen on that day is that they will say, we have a Part B case pending, can we get a postponement because we have this, what we call parallel proceedings. Forget about what Justice Wallace had to say about it, but it's there. So there's nothing, there's no basis upon which we will not get redress in due course. Zero. And that's the only submission they make, which is untruthful and unsustainable, just in logic, that the prosecution will be underway. It won't be underway, but if not complete, where? So, even if we were to forgive them for the undue delay, Justice Mulate, the second leg of no redress in due course, they fail dismally on the basis of what I've just said. But be that as it may, let's assume there's no issues of agencies, there's no issues of jurisdiction, there's no issues of preliminary litigation, there's no issues of locus standi. Mr. Ramaphosa was in this court in his proper incarnation. Just purely on the requirements of interdict, which we have already addressed in what I've just said. Prima facie right, I don't want to quibble about that for now, on the basis that we discussed Justice Mulate. Harm, zero. Alternative remedies, zero. Balance of convenience, zero on their side. Why? Because the issue of balance of convenience is also related to the harm. And it is not correct for Mr. Manache to say that the outer principle does not apply to the private prosecutor. That's a misconception of our law. Firstly, outer principle applies. Let's just talk about its application generally. It applies because what they seek or what they sought, I don't even know, because they've done an amendment which is not an amendment. Remember the relief they sought, they said the respondents, all the respondents must do ABCD, which is classical outer relief, where you want to interdict interim, rather statutory or constitutional powers from being exercised, either by the registrar or the NPA. Let's put aside for now the issue of the private prosecutor. So this was quintessential outer territory. and yet they did not plead it. I'm not saying they did not fulfill the outer requirement. They did not plead. The owners bearing party did not plead those. What is that? How can you say the registrar and the MPA must be interdicted from A, B, C, D, and you don't mention outer, and you expect to succeed? In which court in this country can that happen? When the Constitutional Court has said so many times that in those circumstances there must be these extra requirements, which we call outer requirements. So they're out on that basis alone, not pleading, not alleging even, rightly or wrongly. So they fail to do that. Then they come with this argument now to say, oh well, the MPA is not opposing, the registrar is not opposing, therefore it's only the first respondent now, and therefore no outing. I mean, it's an opportunistic. How do they know that there is some rumors that they knew when they were doing the notice of motion that the MPA is not going to oppose and the registrar is not going to oppose? Of course they didn't. It's just what the late Judge Bezos used to call it, ex post facto rationalization. Now, let's give them that. Let's say now, let's just talk one-on-one. The private prosecutor is equally a beneficiary of the outer principle. Why? Because in terms of Section 12 of the Criminal Procedure Act, when the private prosecutor prosecutes, he or she steps into the shoes of the MPA, to put it colloquially. That's what that section says. Yes, got the right one. I was just about to give my learned genius the look. It says, a private prosecution shall, subject to the provisions of this Act, be proceeded in the same manner as if it were a prosecution at the instance of the state.
What section is
Section 12.1, my lord. 12.1.
12.1
12 bracket 1, yes.
of the CPA.
Of the CPA. Now, what does that mean? It means that the private prosecutor, for the purposes of this exercise, is exercising the powers of. That's why we have that convoluted thing of certificates. I know Mr. Marwana doesn't like it because he says even that is itself an invasion of rights. But it is what it is. So the reason why you must have the certificate is because the primary institution that is constitutionally ordained to do prosecutions is the NPA. But once they decline, or as in this case abdicate that responsibility, then the private person steps into their shoes. That's number one. Number two, there can be no debate about is that when a private prosecutor exercises the powers under Section 7, they are exercising statutory powers. So what they want to interdict is the exercise of statutory powers in the hands of the private prosecutor anyway. So this is the heartland of outer. Outer is not just a little gimmick. It is based on the following proposition. Whether it's the prosecution services or a minister or a DG or whatever, the principle of separation of powers say that the courts must be reticent to interfere with that just out of comity or deference or the separation of powers doctrine. So once the separation of powers doctrine is triggered, the court must ask for a little bit more than in the Citrojelo situation. That's all that outer is. So it applies. And they didn't plead it. But not only did they not plead it, they did not meet its requirements in any event, even if they had pleaded it. Because there's no allegations of exceptional circumstances, there's no allegations of the so-called clearest of cases, and there's no non-addressal of the separation of powers harm, which is what outer is all about. And that approach was confirmed in the EFF versus Godan case subsequently. And it doesn't help my learned friend to talk about the peak. Of course, in the EFF versus Godan case, it was said that the interdicting court has a right to take a peek into the merits, obviously, because how do you say there's no prospects of success without peeking through the merits? Not for the sake of resolving them, but just to see, looking at the strength of the case. But that paragraph in the EFF versus Godan case, I think it's paragraph 42, starts with the words "in addition." In other words, the judicial peak is not the be-all and end-all of the inquiry. It is in addition to meeting all the other requirements, you are allowed to have a judicial peak. So you can't peg your entire non-compliance with outer on.
Well, thank you for that. You're coming to the end of your time, Mr. Mpofu, so please wrap up now.
Yes, yes. In our big bundle, unfortunately, because of electricity and all these things, we couldn't upload it. So we only have the physical page pagination. It's page 111 of that bundle, the physical pagination.
What is that part of? That's at Godon's case.
That's the Godon case. And paragraph 42 is the one I was referring to. And I won't read it, but I just wanted to highlight the fact that it says, in addition, before a court may grant an interim interdict, it must be satisfied that the applicant for an interdict has good prospects of success in the main review. The claim for a review must be based on strong grounds which are likely to succeed. And that's the key phrase in that case, which has now been used subsequently, likely to succeed. This requires the court adjudicating the interdict application to peek into the grounds of review raised in the main review application and assess their strength. It is only if the court is convinced that the review is likely to succeed that it may appropriately grant the interdict. So the key words there are in addition and may. So in other words, all the other requirements are still intact. You can't, it's impossible. I mean, even my learned friend, Mr. Manager, with all his skills, cannot be able to establish outer requirements when they were not even pleaded, and when he bears the onus. It's just a no-brainer. The case is dead in the water before it gets off the first floor.
Right, we've got the point.
Yes. Is it bought? I think it's bought by. I'm sorry. 0011-158. That's our hand. 0011-158. I've just been. Paragraph 195 of our list.
195.
195.
Yes.
We relied on a case of Bortma. It's not Borta, it says Borta, it should be Bortma. Bortma versus else. Page 65 of the authorities bundle, and it's paragraph 29. I'll just read it as paraphrased in the heads, hopefully that captures it accurately. But it says, it was correctly held in Borta versus House and others that an accused person in private prosecution is clearly protected by the broad fair trial requirements of section 35(3). No further protection is therefore required in the form of any interim interdict. Now, what this says, my lord, and this is a point, I'm glad that we've come to this point, because I want to just explain, it covers many other things. The Lordship, Mr. Justice Mulafe, has explained that some of the rights that are being asserted are constitutional rights. I want to take it further to say that if you look at the rights under prima facie right, you'll see that apart from dignity and reputation, there's also an assertion of fair trial rights. Now, this case therefore says that those rights, and this is a constitutional court decision, should generally not be protected in the form of an interim interdict, because 35(3) is there. Now, what does that mean? It cuts both ways. Firstly, it shows you that there are alternative remedies. But secondly, it also does away with this notion. It's that earlier point, a lot, that we spoke about the utility or purposelessness of this interim interdict. Because you see, the minute Mr. Ramaphosa says, I am asserting my fair trial rights, then we should not be here. And then the so-called step-aside thing also is proven to be a red herring. Why? Section 35(3), unlike the other sections of the Constitution, which says every person or all citizens or all individuals, Section 35(3) starts with the following words: every accused person. So the rights in 35(3), which he wants to assert in this court, are rights of accused persons. And the rights of accused persons must be exercised in the criminal court. So it's maybe an indirect admission by him that he now accepts, unlike what he did, he wrote to us on the 15th of December, that he's an accused person charged in front of a court of law. But the point we make is that, of course, he is an accused person. Of course, he's a recipient or a beneficiary of the 35(3) rights, but they are not to be exercised in this court.
Isn't the unfairness raised in the context of the averment that they no prosecute and therefore the summons are unlawful?
Yes, that's the heart.
Yes.
Yes, no, your logic is correct. That's why I said, if you cut all the verbiage, the central issue in front of you is the certificate. But if I'm correct in my analysis of the certificate as being of application to this particular person, that's the end of it. That's really the end of it. Because then we're into the world of, then like any other accused, you must go and so on and so on. Why should he be exempted from Section 55 of the CPA or Section 158 and so on? Then we're in or 106 even, where other accused persons have to raise that as a matter of plea under Section 106(1)H.
Thank you, Mr. Mpofu.
As court business, those are our submissions. In the results, we respectfully submit that this application should be dismissed with cost, and for the reasons I won't go into some of the issues which were also touched on by Mr. Malala about equality and the arrogance of even bringing an application like this. But we do persist in our prayer for punitive costs, and because really, as you say, we even gave advice on this. And if the court allows me just 1-2 minutes, paragraph 20 of our I'll just read it verbatim without editorial, of our heads. We make the point that straddles both the merits and this issue of cost. Justice Wallace J.A., again decrying this tendency to do all this. I mean, one of my juniors told me that the papers in this thing are now more than 3,000. For what? 3.9, almost 4,000.
Well, am I to assume, Mr. Mpofu, that you did not settle your own papers?
Well, not all 4,000 of them, let me just say. Even I don't do that. It says at paragraph 20, there is no law for presidents and other law for ordinary citizens, quote unquote. There is no separate law for the rich and famous and other law for the unknown citizen. It is identified by Wallace J.A. in the Moyo case, paragraph 169 as follows, and I quote. He says, the trial has not yet commenced, as in here. It is commonplace to see in the media that the first step in any criminal litigation involving a prominent person is that they will challenge the constitutionality of the charge or the process leading up to the commencement of the criminal proceedings. The term, quote, Stalingrad defense, quote, has become a term of art in the armory of criminal defense lawyers. My learned friend is not a criminal defense lawyer, fortunately. By allowing criminal trials to be postponed pending approaches to the civil courts, justice is delayed and the speedy trials for which the Constitution provides do not take place. I need hardly add, said Wallace J.A., that this is of particular benefit to those who are well-resourced and able to have the services of the best lawyers, which Mr. Manager is.
You agree with that part?
I agree with that part in the case of Mr. Manager. Well-resourced, there's a typo that says well-resources. But, and that's my last submission before I sit down. This abuse of the court process by those who are rich and who are able, in this case, those who are actually using state resources wrongly, because it's not been charged as a president, then amounts to this 4,000 pages to try and do what? This case is about one thing and one thing only, to avoid the appearance next week. It's all this other gymnastics, forget about it. It is simply to avoid the simple thing that every accused person in this country every day does, which is when you are arraigned, you go to court and then do your case. That's all. There's nothing else. Forget all this. Because they know that it's going to be a 30-minute postponement, as it always is in the case of any other accused. And arrangements will be made for the next appearance and so on. Probably the Part B situation will be accommodated. That's it. But no, that's for the other 60 million inhabitants of South Africa, not the high and mighty, not the president.
Thank you, Mr. Mpofu.
Mr. Zuma, to say this, my lord, if there's a single person in this country who has been in and out of these courts for the past, I don't know how many years, believing that he is being persecuted. But all of us, I'm sure, have seen an image of him somewhere, going into court, sitting, going out, going in, going out. Never has he said, this is beneath me, this idea of being charged.
We have the point, and thank you very much for your submissions.
That's good.
Thank you. Now, are you not here?
Yes, if I may just say that since we have been told that our scholarship, as you termed it, is not required for purposes of determining Part A, and that we should consider joining Part B, perhaps as a party or still as an amicus. Can I ask to be excused? I have a daughter to fetch from school.
Yes, no, indeed.
My learned friend will be here to take notes in relation to any issues that may arise in relation to Part B.
Yes, forgive me if I didn't make it clear that you were not required to remain. I assumed you had stayed on because of your material interest rather than anything else, but certainly you may be excused, Mr. Ngulwana. And we'll sort out the niceties of the joinder outside of court and deal with that as expeditiously as it can be done.
Yes, we shall have a conference with our learned friend and then appoint.
Thank you.
Thank you.
Thank you, Mr. Matabedi, you want to say anything?
As it is in the court, may I be permitted just to deal with two matters that arises from advocating
Yes.
this argument. I imagine the news headline will be NPA shielding the president. My Lord, we respectfully submit that there is no factual and legal basis for making such an insinuation. And even if one has a careful look at the papers, there is no evidence to back up that. I submit that is after the speaker. It's pure speculation.
Yes.
And the second issue relates to the fact that we've been told that the first and second and third respondent are saying nothing about the certificate. If we can have a look at the answering affidavit of the second respondent at page 009-125, paragraphs 3 reads as follows: I shall deal with my comments and concerns insofar as part 2 is concerned at the appropriate time.
No, I did note that. You're still to answer that.
That's correct.
Yes. No, I understand that.
As it is.
Thank you, Mr. Matabedi. Mr. Manechi.
As the court pleases, I shall not try to match my learned friend, Mr. Mpofu, in the number of words I will use. I will limit the case to what the case is about. The first point is the jurisdiction point. And we all understand that jurisdiction is about power, is about competence. And the question is whether there is a hard question. It's not a question of preference, inclination, it's whether the power is or isn't. And I refer to the case of Solomon, which is in this division, which makes it very clear that the court has inherent power to protect any accused persons exposed to private prosecutions that are irregularly instituted. In other words, in non-compliance with the provisions of the CPA. And the court, the court said, we had argument that you can go to the criminal court and various provisions of the Criminal Procedure Act have been highlighted, as my learned friend Mr. Mpofu did with references to section 106, section 158. What the court said in that judgment in Solomon, which was followed by subsequent decisions, is none of those provisions oust the inherent power of the High Court to protect a party that makes out a case that the private prosecutor has instituted private prosecution irregularly. Because the only time that a private prosecution can be instituted is if it complies with the provisions of Section 7. So, and you didn't hear anything from my learned friend, Mr. Mpofu, about why there is an argument that Section 106, Section 158, or indeed any other relevant provision of the Criminal Procedure Act has that ousting effect of the inherent power of the High Court. None of that. What he did accept is that he can't say that where harm is manifest because of a breach of rights, that the court will close it. He accepted that, but qualified that by saying what the Constitutional Court has said is that parties should go into the criminal court, not divert criminal proceedings into the civil court, must avoid preliminary litigation and the like. All of that is about preference, is about inclination, is about whether exceptional circumstances justify a court taking up a case. They don't answer the hard question whether there is power or there is no power. And that power remains, is inherent in the High Court. It is not taken out by the Civil Procedure Act. And there is no case that my learned friend referred to that says Solomon was right, Solomon was wrong, Jeffrey was wrong, Neko was wrong, I always get it.
Nunadal, yeah.
Nunadal was wrong. So there's no answer to the jurisdiction point. We assert there is jurisdiction, this court can grant relief. There is a second bar or third, whatever, to his argument. He says, well, maybe our learned friends are correct that final relief may be granted in Part B or by way of final interdict. And that's all those cases that they refer to have said or have done. But what he misses is that in that is a very important concession, is that the High Court can give final relief in the form of a setting aside or in the form of a meeting. Now the cases are very clear. In fact, the Air Road Express judgment, it wasn't dealing with what my learned friend said, it's about licensing, where you have a review pending an appeal in an appeal board, which is not the court itself. Whether in the usual case, an interim interdict is granted in the context of proceedings pending in the court, and the court was asking whether that principle can be extended to give a temporary license to somebody whose prospects of an appeal in an appeal board regarding the refusal of the license can in the meantime be granted an interim license. And the court said that inherent power, and I've indicated, is a salutary power which must be jealously guarded by the courts to prevent injustices such as where a person is to be hauled before a private prosecution unlawfully. That power remains. So the concession that you can give final relief, it's implicit in it is a concession you can give interim relief. Because if the interim relief is granted so that the final relief is not ultimately vacuous and nugatory. It is simply to maintain the status quo so that your rights are not finally, irremediably trampled upon. The so-called 30-minute harm. My learned friend at least concedes there is harm, but it's for 30 minutes. But we know that he's simply saying that in the ordinary course. But of course, criminal proceedings, when they are postponed, they remain underway. So it's not just he's 30 minutes and he's out of there, no criminal proceedings, they carry on. So on the jurisdiction point, with great respect to my learned friend, there is no answer. There is no answer. There are various references to criminal cases dealing with public prosecutions. And all of the cases we refer to make a clear distinction between public prosecutions and private prosecutions, because private prosecutions are statutorily conditional. If the conditions are not met, there is no law for private prosecution. So we submit that that is established. The second point is harm. We refer to the Van Dieffen judgment, where the judge in that case, the JP in that division, said harm is manifest because your freedom of movement is harmed. If we live just at the freedom of movement, is an important freedom under our constitution. Just like I refer to it, because of the experience we come from. It is important that if your right, your freedom of movement is to be curtailed, it must be curtailed lawfully. Now we make out a point, we make out a case that this prosecution is prima facie unlawful. Why must my client be exposed to an unlawful prosecution in the context of the CPA for private prosecution? It's different from the multitudes that my learned friend keeps referring to, the 60 million people who are charged by the public prosecutor. The cases consistently make the distinction, and we make the distinction, because those are instituted by the rightful authority under the Constitution. He wants to bypass that framework under the Constitution. That's what our argument under the certificate, which I come to. He wants to bypass that. You can't, the courts can't permit that to happen. It is the rule of law, and we refer to the judgment of the Chief Justice in our introductory part about the rule of law and the importance of the rule of law, and ironically in the Nkandla judgment concerning this first respondent. And there, if I can just, it's at paragraph 12 of our heads at 011-7, we refer to this, that the Constitution does not allow the courts to permit this deliberate and unprovoked abuse of highly coercive and invasive statutory or state power by any person. As the Constitutional Court reminded us in the Nkandla case, the values underlying the Constitution, including the rule of law, must be observed scrupulously. If these values are not observed and their precepts not carried out conscientiously, we have a recipe for a constitutional crisis of great magnitude. If a state predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. That obligation rests on the courts too. Just imagine, this happens in a highly contested political context, where in the nature of politics, people use all that is available at their disposal to disadvantage their opposition. Now, if this is permitted when there is a clear case of at least at a prima facie level of non-compliance, one can imagine how that principle set out in Kandla is undermined. And that, you can multiply that to multitudes of all of us. In Solomon, the kind of abuse that was identified was an abuse by a business competitor trying to disadvantage another business competitor using a private prosecution in circumstances where the issues he wanted to privately prosecute had already been determined in an arbitration which was made an order of court. And there was clearly no interest to prosecute, no peculiar or substantial interest. And the court said, the court is bound, it has a power to intervene. Intervene, there finally, we're saying you intervene only temporarily. You're not taking Mr. Zuma's private prosecution right away. In case he has, indeed, in Part B, he can sustain the right to prosecute. Then he will prosecute. But he must do so lawfully. He's got no right. Nobody has any right to privately prosecute anybody outside the provisions of Section 7 of the CPA. With respect, the local standing point is laughable with great respect, because the complaint by the first respondent to the president to investigate was directed to him in his capacity as the president of this republic and addressed to the union buildings. And it is at the union buildings where the president received this request and wrote a letter to the Minister of Justice in his capacity as the president, asking his cabinet member, who is responsible for the NPA, to conduct an inquiry, and asking him to ask the LPC, which is responsible for our colleague Mr. Brady in Cape Town, to conduct an inquiry. The complaint is that in that capacity, he has failed to perform his functions. He is an accessory after the fact. He has defeated the ends of justice. Now today we are told there is a Ramaphosa, a juristic question, probably Mr. Ramaphosa, some other kind of being somewhere, and then there's the incarnation here, which is a president, which, with great respect, if it's splitting hair, that is the worst kind of splitting hair. Then with respect, they say, the next point they say, well, Outer says you can't just say you have a right of review, and therefore that right must be protected by the interdict. We don't say that. That's paragraph 50 of Outer. We're not saying that. We are saying he's got a good case on review. He's got a right which is open to irreparable harm if it is not protected by way of an interdict. That right is the harm premised on the CPA. It's not a harm based on a review, a right of review under patch of legality. That will come in the ordinary course. He is protecting his right peculiarly premised under the CPA, different from the rest of us who are prosecuted by the National Prosecuting Authority. So with great respect, that is no answer. To suggest that we didn't plead outer. When do parties plead law? We plead the facts, and the facts on which we plead, I must argue to the court, persuade the court that the facts on which we plead meet the outer requirements. Now I say the prima facie case is strong, and I'll come to the certificate. And so that's an outer requirement. I say there is no separation of powers. Mr. Zuma is not part of any arms of government. That's where the separation of powers doctrine is located. At best, it's exercising statutory powers, but as a private person. Even if we had to meet outer, we meet it. There is no separation of powers harm that the court must take into account. And Justice Sutherland will recall in Bidvest, we also try to persuade you that when you are awarding tenders and the likes, that's also an exercise of public powers, and you said you're just procuring goods. Here, he's just privately prosecuting for his so-called peculiar and private interest. He's not protected by any separation of powers harm. So, outer is not a constraint, but if outer is a constraint, we've shown it, because we showed a clearer case, and we've shown that separation of powers harm doesn't apply, it's not an arm of government. And to the extent that the case says it's either a clear case or the exceptional circumstance. It doesn't say you must show both cumulatively. And this is an old, you recall it comes from Gold, the judgment about the Minister of Police or Justice, if I recall correctly. It's an old statute, it's this old approach that if you was restraining the exercise of public powers, you better have a very strong case because you're implicating the public interest. You're only implicating Mr. Zuma's interest. So there's nothing there. Then they say, well, there's an alternative remedy. The alternative remedy is, with great respect, a demonstration that there is no alternative remedy. Because they say, come to court and then exercise your alternative remedy. Because Section 106 is to be raised in the criminal court. Section 158 is to be raised in the criminal court, or he must apply to the criminal court. All the other remedies, Part B, they say, well, Part B is a remedy, but Part B means he doesn't get a remedy today, and next week he goes into the criminal court. So the whole premise of their alternative remedy argument is that he must go to the criminal court. That's precisely the harm that we want protected against. And Fadiyafenta said that harm is manifestly urgent and must be protected against where a case is made out. So there is clearly no alternative remedy. If this was genuine, with great respect, that Mr. Zuma wants to throw a lifeline to my client to avoid him asking for interim relief, he would have removed the criminal case from the roll next week, as happened in Fadiyafenta. I read from the passage in Fadiyafenta. He doesn't want to do that. He says, well, the president wants to avoid appearance next week. Yes, because that harms his rights. But where are the rights of Mr. Zuma that will be harmed if he simply removes the thing from the roll and let Part B be expedited? Both my friend and I have litigated in this court. We know how efficient this court is in providing earlier dates for Part B review. Why can't he do that? Because there is an ulterior purpose. He wants him in that door for his political reasons. Otherwise, if it was a genuine litigation, you wouldn't have this digging in the heels. They would simply be saying to our attorneys, can't your client just agree that we remove the matter next week from the roll, we expedite Part B, we get ahead in 2 months or 3 months? Everybody has a clear answer. If the answer is against Mr. Zuma, and there are things that he must fix in order to prosecute Mr. Ramaphosa, he will do so. If there is nothing he can fix, that's the end of it. That's what the law is. So with respect, there is no point there about alternative remedy.
Mr. Manager, just to clear up in my mind, if assuming the summons and the nollie were lawful, in that instance, surely then one would say there would be an alternative remedy. If they were lawful and we had no other complaints, yes. So we couldn't say, for instance, they are all lawful, but this prosecution for an ulterior purpose because the underlying complaint could never be a criminal offense. Yes, because your alternative in that instance would surely be to go and plead in the criminal court.
Possibly. I don't have to.
Yes, no, just as I clarified in my mind.
Yes, so there would be, I would have to, the president and his advisors would have to think carefully about it to see whether the door for interim relief is still open. But standing here, I can't say there would be no case at all for interim relief because even in Fadiyafenta, where the criminal offense alleged was that a judge decided against a party. Even if the certificate is valid, in other words, it was based on an offense placed before the DPP and the DPP decided, there may still be the question whether is this a case that can be won. And in Lundalala, they make the point that where you have a frivolous and vexatious case prosecution, that is an instance of a lack of substantial or peculiar interest. So you can't have a substantial interest in litigation that is merely vexatious. So there could still be an argument, but for President Jacob Zuma, I can accept the proposition that there would be more challenges, but the point is that's not the only issue here that we're dealing with. And I'm not making a concession. I know my learned friend likes to extract concessions from his colleagues. I'm not making a concession. I've been with him, he's my good friend, but I think on this one I must be safe and say, but that's not a concession. And so there is no alternative remedy. And then the real point is, well, here's the real point. And he's embarrassed to make this point against his colleagues. I mean, he should be embarrassed if we simply don't understand the fundamentals. That's how far we go back. He says, you know, they don't understand that an accessory after the fact is a crime whose involvement, which is committed sometime after the primary offense is committed. He said the determining factor is the time of involvement. We agree with him. It is the time of involvement. When you go back to the knowledge prosecuting certificate, which I took the court to, and I don't want to go back there, the DPP makes it very clear when that time of involvement was. He says the crime was committed on 9 August 2021. That is the time of involvement.
2022.
2022, I beg your pardon. 21.
21. Oh, okay.
So the point is this, which my learned friend misses. It's not about the definitions of the crimes. We all understand it. Maybe he understands better, but we all understand the basics. The real point under Section 7, and we have referred to Section 7 in our heads in detail and underlined the relevant parts. The important point is, was the DPP at the time of issuing the knowledge prosecuting certificate seized with a complaint about an offense of an accessory after the fact? And the DPP certificate tells you, no, I was seized with an offense committed on the 9th of August 2021. That doesn't mean that subsequently the DPP might not be seized with the correct accessory after the fact complaint. But we are, to get there still, we can't now say, well, because it's possible in the future, academically possible, try to rejig the certificate and find that that certificate is capable of applying to a crime committed whose time of involvement is the 25th of August 2021. And that is the question, the point raised by Justice Sutherland about purpose of interpretation. Purpose is to be sought from the statutory framework and from the document. And the statutory framework tells you very clearly, in respect of a knowledge prosecuting certificate, and at 011-21, we quoted the section. It says, Section 7, private prosecution on certificate knowledge prosecute. That's the heading. 1. In any case in which a director of public prosecutions declined to prosecute for an alleged offense, it must be an alleged offense for which he declines to prosecute, and you go to the certificate and say, which is that offense? Any private person who proves some substantial and peculiar interest in the issue of the trial arising out of some injury which he individually suffered in consequence of the commission of the said offense. So you keep going there. May, either in person or by a legal representative, institute and conduct a prosecution in respect of such offense in any court competent to try that offense. And 2A says, no private prosecutor under this section shall obtain the process of any court for summoning any person to answer any charge unless such private prosecutor produces to the officer authorized, the registrar, by law to issue such process a certificate signed by the Attorney General, DPP, that he has seen the statements or affidavits. It's not just seeing the statement or affidavit, which is what Malenfred goes on about the press statement being inaccurate. It's that he has seen the statements or affidavits on which the charge is based. That's the offense. And that he declines to prosecute at the instance of the state. He declines to prosecute the charge, the offense. So the statements on which one relies must tie back to an offense, must disclose an offense against the president. So when I read to the court the paragraphs quoted at 011-112 of our learned friend's heads of argument, at paragraph 42, I showed you that all they report to the DPP is that they've also complained to the president, and the president is investigating. They don't at all complain that the president has failed to investigate and is an accessory after the fact or is defeating the ends of justice. If that was the case, then the knowledge prosecution certificate would have dealt with an accessory after the fact crime. It would not have limited itself to the primary crime. And the certificate must speak, because the certificate is proof of what it says. So with great respect, we have it's almost a clear case that the certificate in fact doesn't apply to my client. But we will establish it more definitively in Part B.
You're going to wrap up now?
Yeah, I'll wrap up now. Then it's just agency. I think I've covered agency somewhat because I referred to Van Geffen and I referred to the fact that there's no alternative remedy. The criticisms about getting there, my learned friends, we excuse you up to the 21st of January. But what it doesn't tell the court is in that excuse, his attorney wrote to our client and said, can they withdraw conditionally the 15th of December 2022 summons and reissue it, accepting that it was defective or it has defected and it has to be corrected, which they then corrected on the 21st. And once it was corrected, the president and was issued, the president was left with no alternative but to come to court. To suggest that 6 days for lawyers working on an application of this kind, which our learned friends raises complex issues, to come to court, to finalize and come to court in 6 days or 7 days, really is not a matter that denies an applicant access to this court for agent relief, where they clearly there's no remedy in due course, and it's almost common cause that there isn't, because the other remedies are not remedies. And requirements, our learned friends so boldly asserts on requirement this zero, requirement, that's not the way one persuades a court that the requirements for an interdict have not been met. Prima facie right, we've shown on the certificate, we've shown on the irreparable harm that will suffer, the right that we count. Balance of convenience, you search in vain what the prejudice is that Mr. Zuma will suffer. But my client will suffer clear harm. Alternative remedy I've addressed. What's the other? Balance of convenience, he doesn't have separation of powers arm, which is what he kept talking about. But clearly here, the balance of convenience favors my client. I've dealt with outer. He says he's benefiting from outer. He doesn't. He's not a branch of government. He's just the former president who is a private citizen. So with great respect, this application has a lot of emotion, has a lot of political innuendos in the affidavits exchange. But the key issues before this court are crisp, and this court must determine them on the facts and on the law. And we've given the law, and we submit that on that law, we're entitled to the order we seek against the first respondent and costs on a party and party state. Unlike them, we're not doing tit for tat. We ask for party and party costs. Those are sufficient.
Thank you. Do you want to say goodbye, Mr.?
Yes, my Lord, but in a few minutes. My Lord, I won't exercise my right of reply.
What is there to reply to?
Well, to the points about, well, nothing, that's the answer. That's the short answer. But insofar, I wanted to say, insofar as Mr. Anete has spoken about the issues that he didn't raise in front, like frivolity and so on, I'll just let that go by. The only reason I'm standing up, my Lord, is just to make 2 quick points. One is this, and you'll find that it's 00922. There's an allegation, at least from the private prosecutor, that says it is wrongly associated with the mainstream media and others who have a personal animosity towards me, including the applicant, with state capture, 9 wasted years, even though the applicant was my loyal deputy and so on. The only point I'm making there, my Lord, is that it goes to this issue about the capacity. So if somebody, and Justice Mulatle, his example, if let's assume there is bad blood or whatever, if someone exercising that bad blood as a person, not as a president, is then motivated to, let's say, ignore the request to do an inquiry, then that person cannot then come and say, well, I did that personal animosity thing towards you as a president, because they would not be in any different position than the corrupt traffic policeman that I spoke about. So that's the only point I wanted to make. But I don't think that...
No, we've got the point.
Thank you, Madam. the issue, the reason why I really don't have a reply to Mr. Magnachi is because he spent half of the time addressing the one point that I had considered. So, which is the fact that let's assume there's jurisdiction, and then he goes on and talks about that. The point I want to address is Mr. Matibedi. Mr. Matibedi must not abuse this platform with the greatest respect. To come here with whatever that Afrikaans expression made, and he says it's speculation. It is not speculation, my lord. It's a matter of serious constitutional import. If the National Prosecuting Authority, which is supposed to protect all of us, supposed to be independent, supposed to stay away from this whole thing, they've done their part, they've done their nolle prosecute, that's all. But on the 21st of December, they wait until Mr. Ramaphosa is elected at the ANC. Before that, they were kept quiet. On the 21st of December, they issue a statement, unprovoked, which contains a lie that says Mr. Ramaphosa is not mentioned in the affidavits, which it is. It's a lie, okay? It's not speculation. Now, if that and all we are saying, we then attack it ad nauseum in our answering affidavit. We say, this is a lie, this, that, and the other. They do an affidavit, ma'am. They don't say, by the way, we stand by our false statement. They just keep quiet. That's disingenuous. So those issues, I agree, will be dealt with in Part B. But we cannot come and stand here and pretend that everything is well when the independent prosecution sides openly with the person who appointed the National Director of Public Prosecutions. But the person who, Ms. Zuma, to her credit, who did the certificate in KZN, is not involved in this politics of head office. She puts an affidavit and she says, this is our situation. Our involvement would come under Section 13, and Section 13 if the person pleaded guilty, or if we wanted to take over the prosecution. It doesn't look like that will happen, therefore we are out of it. Full stop. She doesn't own or taint herself with the nonsensical statements that were made about that Mr. Ramaphosa is not mentioned in statements when he's physically mentioned. So
now we've got that. Thank you.
God,
Thank you, Mr. Mpufu. Yes, thank you very much for your arguments. What we're going to do now is we will reserve judgment, and judgment will be delivered at 9:30 on Monday in this court. The court will now adjourn.
Thanks, guys. Thank you.